hum, chi, 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 hum, chi, chi, hum, chi, chi. థర్డ్ ఫ్లోర్లోనే గురు థర్డ్ ఫ్లోర్ హల్ చెక్ ఏంటివి ఏంటివి ఏంటివి
On behalf of the organizing committee, I am deeply indebted to our Honorable Chief Justice for kindly giving consent to inaugurate this conference, and I feel that we are all honored. Thank you, sir. Thank you very much. I am also highly grateful to our Honorable Chief Justice of Telangana High Court for kindly gracing this inaugural session. Thank you, sir. Thank you very much. What a great pleasure it is to be here with all the delegates today. We are delighted to have you all with us to participate and share in our one-day NTC. The organizing committee has commenced preparations in February 2024 itself. Several committees have been formed to comply with the assigned tasks. All the chairmen and members of the committee sacrificed their time and energy and worked hard to present this today. Beauty of our conference is that even our national president has to pay the delegate fee. We are proud to announce that in the year 2026, Aiftp would be celebrating Golden Jubilee. Earl Nightingale said, "All you need is the plan, the roadmap, and the courage to press on to your destination." Fortunately, our committee members had all the three requisites, and hence we could reach destination successfully. Still, if any omissions are there, I take full responsibility, and you may all excuse me. We are fortunate to have the support of advertisers and sponsors, and the organizing committee bows down for their generosity. We are also thankful to chairmen and speakers of technical sessions for giving their consent. The e-souvenir brought out on the occasion would be really useful to the delegates with its subject contents. I am sorry to note that our Sri K.H. Rao Garu, first chairman of South Zone of Aiftp, and Sri S.H. Rao Garu, next chairman of South Zone Aiftp, who have never missed any conference, both are not among us today. May their soul attain salvation. I shall be failing in my duty if I do not place on record the excellent efforts made by Sri Narsimham, convener of this conference, Sri Chakra Ramana, Saidulu Garu, D. Srinivas Prasad, Sri Vijayan, Treasurer South Zone, Sri Gopal, Secretary TTPA, Hussain Wali, Treasurer TTPA. Finally, Dhanam Moolam Idam Jagat, nothing is possible without money. Our Finance Committee Chairman, Sri TV Subbarao Garu, made this conference happen, and I am happy. I am thankful to him also. I am thankful to all the past presidents of Aiftp South Zone, past presidents of TTPA, and all the past and present GC members of South Zone and TTPA. Thank you all. Namaste. Sarve Jana Sukhino Bhavantu. Thank you very much. I now request Sri Kumar Garu to please recognize the dignitaries who are dignitaries. Thank you, sir. Thank you.
Good morning to you all. I recognize the President of Justice Tukaram Garu, Justice Bhaskar Reddy Garu, Justice Anil Kumar, and our beloved ASG, Narsimha Sarma Garu, and more than him, very close to me, the Senior Standing Counsel of Income Tax, Sri J.V. Prasad Garu, and Sri B. Narayan Reddy Garu, who was the Senior Standing Counsel for the Central Government, and Dominic Fernandez and Swapna Reddy, and Sri Bhaskar Reddy Garu and Jalani Pasha. Thank you very much.
Thank you. May I now request President FTCCI.
I'm sorry, I have forgotten. He is a mentor of mine and a retired Central Standing, I'm sorry, Chief Commissioner, Principal Chief Commissioner. He worked for the state of Telangana, Tamil Nadu and Pondicherry, and he is a Customs Commissioner who worked for the Karnataka state. He is none other than Mr. Srinivas, who is present here. Thank you very much.
Thank you. We once again recognize all your presence here on this day. May I now request President FTCCI Sri Meela Jayadev Garu to speak on this occasion, please.
A very happy good morning to all. అందరికీ నమస్కారం. మా అందరి ఆహ్వానాన్ని మన్నించి ముఖ్య అతిథిగా వేదికను అలంకరించిన గౌరవనీయులైన జస్టిస్ శ్రీ ఉజ్వల్ బయాన్ జడ్జి గారు, సుప్రీంకోర్టు గారికి హార్దిక స్వాగతం అండి. అలాగే గౌరవ అతిథిగా విచ్చేసిన జస్టిస్ శ్రీ అలోక్ కార్డెన్, చీఫ్ జస్టిస్ ఆఫ్ తెలంగాణ హైకోర్టు గారికి స్వాగతం. And today's speakers, శ్రీనివాస్ అండ్ వేదికను అలంకరించిన పెద్దలందరికీ హృదయపూర్వక నమస్కారాలండి. అందరికీ స్వాగతం. అండ్ శ్రీనివాస్ గారు, రిటైర్డ్ ప్రిన్సిపల్ చీఫ్ కమిషనర్ జిఎస్టీ ఫర్ తమిళనాడు అండ్ పాండిచ్చేరి. అండ్ సిఎఫ్పి సాంబమూర్తి, రాజేంద్ర ప్రసాద్ గారు, సుధీర్ గారు, విఎస్ సుధీర్. మా సహచరులు నారాయణ్ జైన్, అడ్వకేట్, నేషనల్ ప్రెసిడెంట్ ఆఫ్ ఆల్ ఇండియా ఫెడరేషన్ ఆఫ్ ట్యాక్స్ ప్రాక్టీషనర్స్. అండ్ శ్రీ కె నర్సింగ్, అడ్వకేట్, ప్రెసిడెంట్ ఆఫ్ తెలంగాణ ట్యాక్స్ ప్రాక్టీస్ అసోసియేషన్. రామరాజు శ్రీనివాసరావు, అడ్వకేట్, చైర్మన్ అండ్ ఆల్ ఇండియా ఫెడరేషన్ ఆఫ్ ట్యాక్స్ ప్రాక్టీషనర్ సౌత్ జోన్. అవర్ కొలీగ్ Suresh Kumar Singhal and Ravi Kumar is the Vice President, and Suresh Kumar Singhal is Senior Vice President, and Sudhir, Chair Direct Taxes Committee, Muhammad Irshad, Chair for GST and Customs. Sri Chakra Ramana, Vijayan, Gopal, Hussain Wali, Nagesh Rani, Narsimham PL. A special thanks to Nitin Parekh for organizing, starting he is the initiative has taken from Hyderabad. ఈ రోజున మనం నేషనల్ ట్యాక్స్ కాన్ఫరెన్స్ సమావేశానికి విచ్చేసిన అందరికీ, ప్రతి ఒక్కరికి ధన్యవాదాలు. ఇలా వివిధ భిన్న మేధావి వర్గాలు, ముఖ్యంగా జస్టిస్, లాయర్స్, అడ్వకేట్స్, చార్టెడ్ అకౌంటెంట్స్, కాస్ట్ అకౌంటెంట్స్, లీగల్ ఎక్స్పర్ట్స్, జిఎస్టీ ప్రాక్టీషనర్స్ అండ్ స్పీకర్స్, వీరందరినీ ఒక చోట కూర్చోబెట్టడం అంటే మామూలు మాటలు కాదు. పారిశ్రామికవేత్తలు, పారిశ్రామికులందరూ ఒక చోట సమావేశం అనేది చాలా అరుదు. కానీ ఈరోజు మిగతా అన్ని అడ్వకేట్స్, లాయర్స్ అందరినీ ఒకే చోట కూర్చోబెట్టి మాట్లాడటము, వారికి సెమినార్ ఇవ్వటం అంటే అది చాలా ప్రత్యేకత. తర్వాత పన్ను చెల్లించడం అనేది మన పురాతన కాలం నుండి ఆనాదిగా వస్తుంది. పూర్వం రాజ్యానికి ఉన్న రాజుని దేవుడుగా కొలిచేవారు. రాజ్యంలోని ప్రతిదీ రాజుకు సంబంధించిందిగా భావించి రాజుకి కొంత శిస్తు పన్ను చెల్లించేవారు. రాజు వచ్చిన ఆ పన్నులతో పేదలకు మరియు మేలు చేయటము, రహదారులు నిర్మించటము, చెరువులను నిర్మించటము, వర్తక వ్యాపారాలకు సంబంధించిన ఏర్పాట్లు చేయటము మొదలగు ప్రజా అభివృద్ధి కార్యక్రమాలు నిర్వహించేవారు. అదే కాలక్రమేణా పన్ను చెల్లింపు అనేది తప్పనిసరి అయ్యింది. ప్రస్తుత కాలంలో మన దేశంలో ముఖ్యంగా 2 రకాల పన్నులు ఉన్నాయి. ప్రత్యక్ష పన్నులు, పరోక్ష పన్నులు. వర్తక వ్యాపారులకు సంబంధించి పన్నులు అంటే ముఖ్యంగా ఇన్కమ్ ట్యాక్స్. దేశం మొత్తం ఒకటే పన్ను ఉండాలనే ముఖ్య ఉద్దేశంతో ఒకటే దేశం ఒకటే పన్ను నినాదంతో మన భారతదేశంలో జిఎస్టీని జూలై 1, 2017 ప్రవేశపెట్టారు. అలాగే శ్రీ మహావీర్ త్యాగి అధ్యక్షన డైరెక్ట్ ట్యాక్సెస్ అడ్మినిస్ట్రేషన్ ఎంక్వైరీ కమిటీ 30 నవంబర్ 1959లో ఇన్కమ్ ట్యాక్స్ యాక్ట్ కూర్పునకు సంబంధించిన రిపోర్టు పొందుపరిచారు. 1961లో మరికొన్ని సూచనలు కూర్చి 1 ఏప్రిల్ 1962 నుంచి ప్రస్తుతం ఉన్న ఇన్కమ్ ట్యాక్స్ యాక్ట్ 1961 అమల్లోకి వచ్చింది. చిన్న చిన్న మార్పులతో మనము ఎప్పటికీ అదే చట్టాన్ని పాటిస్తున్నాము. ఇలా చిన్న చిన్న మార్పులు చేర్పులు చేసిన ప్రతిసారి ఎఫ్టీసీసీఐ సెమినార్స్, వెబినార్స్, వర్క్షాప్స్ మరియు ఇతర కార్యక్రమాలు నిర్వహించడం ద్వారా మార్పులకు సంబంధించిన వివరాలను పరిశ్రమలకు, అలాగే వర్తక వ్యాపార సంస్థలకు మరియు ఇతరులకు అందించడం జరిగింది. ఈ విధంగా పరిశ్రమలకు వర్తక వ్యాపారాలకు సంబంధించిన అవసరాలను గుర్తించి వాటికి అనుగుణంగా తోడ్పడేందుకు ఎఫ్టీసీసీఐ ఎల్లవేళలా ఒక అడుగు ముందునే ఉంటుంది. వీటితో పాటు సమస్యల పరిష్కార దిశగా కృషి చేయడంలో ప్రభుత్వము మరియు అనుబంధ శాఖలతో నిరంతరంగా పనిచేస్తూ ఉన్నాము. మళ్ళీ పనిచేస్తూ కూడా ఉంటాము. ఈ మధ్యనే ఎంఎస్ఎంఈ రంగాలను దృష్టిలో ఉంచుకొని వస్తువుల సరఫరాదారులకు జిఎస్టీ మరియు చెల్లింపు యొక్క మొత్తం టర్నోవర్ మినహాయింపు 20 లక్షల నుండి 40 లక్షలకు పెంచి చిన్న మధ్య తరహా వ్యాపారులకు ఉపశమనం కల్పించవలసిందిగా మన తెలంగాణ ప్రభుత్వానికి మరోసారి విన్నవించటం జరిగింది. వీటితో పాటు ప్రతి సామాన్యులకు అందుబాటులో సొంతింటి కలను సాకారం చేసే దిశగా కేంద్ర ప్రభుత్వాన్ని కూడా కొన్ని సూచనలు ఇవ్వటం జరిగింది. ఇలా మన దేశంలో పరిశ్రమల వర్తక వ్యాపారస్తుల సామాన్యుల అభివృద్ధి తోడ్పడుతూ మన దేశ ఆర్థిక ప్రగతికి ప్రతి ఒక్కరూ తమ వంతు కృషి చేయాలని కోరుకుంటున్నాను. అలాగే ఈరోజు ఇక్కడికి విచ్చేసిన అతిథులు మరియు నిపుణుల ద్వారా మీకు ఉన్న సందేహాలను నివృత్తి చేసుకునేందుకు ఈ సమావేశాన్ని వినియోగించుకోవాలని కోరుతున్నాను. జై హింద్, జై భారత్. థ్యాంక్ యూ వెరీ మచ్ సార్.
Thank you, sir. May I now request K. Narsingh Rao Garu, President, Telangana Tax Practitioners Association, to speak on this occasion.
A very warm welcome to all the delegates. Good morning to today's chief guest, Honorable Sri Justice Ujjwal Bhuyan, Judge Supreme Court of India, and today's guest of honor, Honorable Sri Justice Alok Arade, Chief Justice, High Court of Telangana, and Aiftp National President Narayan P. Jain, Deputy President Mr. Samir P. Jani, Secretary General and President of FTCCI Meela Jaidev Garu, Ramaraj Srinivas Garu, Aiftp South Zone Chairman, and on the dais, and respected Dr. MVK Murthy Garu and Sri PV Subbarao Garu and other dignitaries of the dais. I welcome you all for today's National Tax Conference being held at Hyderabad, Telangana. As the President of Telangana Tax Practitioners Association and on behalf of our GC members, we feel very much proud and privileged to host this National Tax Conference today in Hyderabad in association with All India Federation of Tax Practitioners, South Zone and FTCCI Hyderabad. Initially, our association was formed in the year 2002 as a Twin Cities Tax Practitioners Association under the able leadership of some of our senior members who are present here. Later on, after the bifurcation of the unified Andhra Pradesh state and the formation of Telangana state, it was converted to Telangana Tax Practitioners Association in the year 2014. Mostly the members of our association are advocates, tax practitioners and consultants practicing in the field of direct and indirect taxes, and are playing a very vital role between the business clientele and the tax departments, and are very active in solving the root level problems of our clients and their day-to-day compliances, tax compliances. Across this stage and before this August gathering, I would like to thank our guru, mentor, philosopher, Sri PV Subbarao Garu, advocate and retired joint commissioner from Commercial Taxes Department, for his overwhelming support, knowledge and support being extended to our association. Thank you very much, sir, for your continuous endeavor in imparting the update knowledge to our members. Thank you once again, sir. And we do remember long back in the year on 6th and 7th July on 2013, sir, that we have hosted a national tax conference in Hyderabad, where the Honorable Judge Anil R. Dave, Supreme Court was present and blessed that conference and made that conference a very memorable event. I would like to extend my heartfelt warm wishes to both the Honorable Judges, National President AFTP, Deputy President AFTP and President of FTCCI for attending this conference and sparing their most valuable time, and to all the participants today's National Tax Conference. And I'd like to thank one and all, including the delegates who are attending this tax conference from other states also. I wish you all the best once again. Thank you, sir. Thank you.
Thank you to the President K. Narsingh Rao Garu. May I now request Dr. Ramachandrayadav Garu, Chairman Aiftp South Zone, to speak on this occasion.
Good morning to all. Respected Chief Guest, Honorable Justice Ujjwal Bhuyan sir, Judge Supreme Court of India, respected Guest of Honor, Honorable Justice Alok Arade, Chief Justice of the High Court of Telangana, our beloved National President and Narayan P. Jain and Deputy President Samir Jani, and our co-partners in this seminar. Very good morning to all. With great pride, I must say that the conference organized today will play a crucial role in in-depth deliberations on tax laws and will be a unique success. The importance of taxes is very high in every country, as the nation is governed, administered, and developed based on taxes only. However, the structure and implementation of taxes are quite complex, and they require simplifications for the benefit of the taxpayer, as emphasized by the great author and thinker Chanakya in his Arthashastra, whose advice remains valid even today and needs to be followed. It is important to note that conferences like this provide a continued study of tax laws and help in advancing our understanding and knowledge, which is vital for the bar, bench, and administration. I anticipate that participants will immerse themselves in the latest advancements in direct and indirect taxes, thereby influencing the very foundation of our nation's trading and business landscape. The hallmark of this conference lies in its ability to deepen our understanding and foster discussions on pressing issues surrounding direct and indirect taxes, alongside ethical and moral considerations in practice. This enriching experience will culminate in engaging questions and answer session with the subject matter experts. Hence, the conference theme aptly embodies the legal and ethical dimensions of taxation. I firmly believe that everyone participating in this session wore a smile of enthusiasm, reflecting their commitment to advancing our understanding of tax matters. Moving forward, I advocate for the regular organization of such sessions to effectively address the challenges faced by both the practitioners and taxpayers, fostering mutual growth and collaboration. Last but not least, the members of the organizing association deserves great appreciation for their hard work in organizing the conference. I thank the conference chairman for giving me this opportunity, and once again, I want to announce a large number of gathering is coming from Khammam. I appreciate and I congratulate the leaders of Khammam, Saidulu and Durga Prasad and everyone for their efforts to make this success, grand success, this conference. Thank you very much.
Thank you, Dr. Ramaraj Garu. Now may I request Sri C.A. Irshad, GST and Customs Committee Chairman, FTCC, to address the gathering, please.
Chief guest of the program, guest of honor, presidents of Ftcci, Aiftp, Ttpa, dignitaries on the dais, off the dais, and distinguished participants. A warm welcome to all of you for this conference. We are nearing the end of the seventh year of GST regime, and we all have our own share of memories from the past 7 years. But one common aspect that touches all of us is the absence of GST Appellate Tribunal. The last 7 years were very significant for all of the stakeholders, especially the taxpayers and the consultants, because of the unique features and complexities that were inherited with this law. Technological innovation, invoice level matching, a new return filing system, etc. As many of us stumbled, there was a dire need for a forum such as Appellate Tribunal, which could have given impartial relief to the deserving. However, during these challenging times, the one and only one forum that stood with the aggrieved were the High Courts and Supreme Court of this country. The writ courts have filled up this wide gap despite their own challenges, especially the large volume of petitions on GST that were filed before the courts. Many decisions of the courts gave all of us a cherishable moments that not only brought cheers to many businesses, but also gave them a fresh breath of life. Be it the decision of Supreme Court in Union of India versus Mohit Minerals, where the double taxation of GST on ocean freight was struck down, or the decision of the Supreme Court in Union of India versus Philco Trade Center, which paved the way for reopening of Tran 1 forms, and the numerous other judgments of various high courts on several matters such as detention of vehicles, the time-barred appeals, input tax credit availment, etc., including the Gujarat High Court decision in Munjal Manish Bhai on 1/3 deemed value of land. And furthermore, the landmark judgment of our Telangana High Court pertaining to arrest provisions under the GST law in the case of P.V. Ramana Reddy versus Union of India. Today we pay a big tribute to the courts of this country, sir, for standing with the trade and giving a big relief to them. On a lighter note, one surprise outcome is that the advocates had a party time vis-a-vis the CS during these 7 years. So although the need for CS was felt much higher than any other time during these years, being a CA and a law graduate myself, I had no hesitation in saying that all the professionals had both challenging and fruitful times during these past 7 years. Lastly, the FTCCI, being a trade body with a legacy of about 107 years, has played a lead role during the past 7 years in disseminating knowledge and hand-holding sessions on the industry. The GST committee of FTCCI has delivered about 1,200 hours of knowledge sessions, trade facilitation sessions, and countless representations on trade issues before the GST authorities. It has also taken up numerous problems pertaining to the trade community with valuable suggestions before the government, which have also been well received and accepted. I hope everyone here has their own share of memories from the past 7 years. I further hope this event will add another line to these memories. And with this, I conclude my talk, wishing everyone a successful career in the years to come. Thank you.
Thank you, sir. May I now request Sri Samir S. Jani, National Deputy President, Aiftp, to deliver his valuable message on this occasion.
Andarki Suswagatam. All respected Garus, I'm from Gujarat. I tried to learn from Mr. Nagesh Rangi how to welcome all. Honorable Justice Ujjwal Bhuyanji, who has been a well-wisher for All India Federation for years together. Honorable Chief Justice, Telangana High Court, the National President, the President of FTCCI, Chairman South Zone, the judges, dignitaries of the dais. Sir, it has been a long history of association of Aiftp and Hyderabad. I remember when Dr. Murthy took over as the president, national president, in somewhere near Hussain Sagar Lake in Jal Vihar. We had a very, very big event, and I was witness to that. Thank you, South Zone, thank you, Hyderabad, for bringing us over here. Well, judiciary have been always kind to All India Federation. It has been a convention that whenever a president takes over, the oath-taking ceremony, sir, is conducted by a Supreme Court judge. That those are the blessings of judiciary to Aiftp. We at Aiftp have an endeavor to deliver 3E: education, ethics, and excellence. I would say it's an epitome of excellence. Educated tax practitioners serve the nation, serve the society, and that is how we supplement the efforts of the government in bringing up the country. I would at this stage miss my duties if I don't appeal any one of you who is not a member of AIFTP is please requested to become the member today, and I thank the organizers for giving me this opportunity to stand before you. Thank you very much.
Thank you, Samirji. May I now request Sri Narayan P. Jain, National President AIFTP, to deliver his valuable message on this occasion, please.
Our most respected Chief Guest, Ujjwal Bhuyaji, Chief Justice of our High Court, Telangana High Court, Justice Sri Alok Aradeji, the dignitaries on the dais, of the dais, the members of the National Executive Committee, our past President Dr. M.V.K. Murthy, and other office bearers who have been holding the positions in the past and present. I am very happy, as Samir Bhai indicated, that we had a big national convention here when Dr. Murthy took over as the president in Jal Vihar in the year 2015. Now the time is coming again for South Zone to take over as president for the year 2026. And incidentally, that year we will also celebrate the Golden Jubilee, 50th year of the AIFTP. So, South Zone has to plan how in a big way it can be done. Today, I can see that hardly any chair is vacant. All chairs are filled in. So for that program, the National Convention this year will be in Gujarat, when our friend Ms. Samir Jani will take over as president, and thereafter South Zone. And my personal thanks to Ramaraju Srinivas Rao Karu, Chairman South Zone, Mr. M.E.J. Kumar, he is a very dedicated gentleman and always with us. Mr. Samboja Chakra Ramana, he has been virtually in contact with me almost every day. Mr. Ragesh Rangi, Conference Chairman, Mr. P.L. Narasimhan, VP AIFTP Telangana State, Mr. Narsinga Rao, President Telangana Tax Practitioners Association, and Mr. K. Narsingh Rao, President Federation of Telangana Chamber of Commerce and Industries. Mr. Narsingh Rao, you had a very active member called S.V. Chachan, Satya Bhagavan Chachan. And he used to be in touch with me. He is no longer there, he has expired. But he used to brief me about your activities. And whatever suggestions I could give for your federation, I used to share with him. Mr. S.V. Chachan. Friends, listening to the speeches of my previous speakers, we can find that our colleagues are very knowledgeable. And we would like that more and more people from South Zone come in various conferences, even as a speaker. I also invite those of who are willing to write, to contribute articles for AIFTP Journal and the Indirect Tax Journal. You see, knowledge somehow we acquire with great dedication, and we use it for ourselves and our clients to plead in courts and tribunals. But at the same time, if we can share our knowledge with our fraternity, that is a big coach for this society. And I can tell you, sometime in the year 93, I started writing a book. Sir, when Dr. Manmohan Singh ji was the Finance Minister of India, and that book, sir, the first time when we tried, it was only 180 pages, and it was sold at 125 rupees. And thereafter, year after year, because of the various judgments from various forums, and also the amendments made in every budget by the Honorable Finance Ministers, it is now about 3,800 pages. And we have completed our journey so far for 32 years. And this year, after the budget comes, the full budget in July, that will be our 33rd edition. And it is in the question answer forum. And somebody was just telling of a conference where Honorable Justice Anil Dave was also present. And our Dr. Murthy was also there. That time also one of the editions of the book was released. I welcome those who are having the book, copy of the book, to kindly share your valuable suggestions so that more questions and answers which are relevant in practice can be included. Friends, I will not take much of a time. I only wish that we have the thoughtful suggestions from our Honorable Chief Guest and Guest of Honor so that we can utilize those suggestions in our practice. Thank you, thank you all, each one of you. Thank you very much.
Thank you, sir. Ms. Banu was mentioning earlier today that these conferences have usually been an internal affair for very long now. So now we are honored after so many years to be graced by the honorable judges' presence today. And on that occasion, to mark the appreciation that everybody at the Aiftp has, may I request Mr. M.V.J.K. Kumar and also Mr. Gopal to please present some saplings to our three judges who are here, Justice N. Tukaramji, Justice C.V. Bhaskar Reddy, and Justice Anil Kumar, as a token of our appreciation for your presence today, Lordship.
May we have a round of applause, please? So thank you, dignitaries, for addressing the gathering. Now it's time to honor the senior members of the Fax fraternity who are relentlessly rendering the valuable services to their clients and community for more than 25 years. In recognition of their such services, our associations would like to honor them, and we request the honorable judges to kindly honor our members. Can we have the profile, Shivani?
The first person we'd like to honor today is Dr. M.V.K. Murthy. Ladies and gentlemen, allow me the privilege to introduce to you a towering figure in the legal arena, Dr. M.V.K. Murthy, whose journey through the law and advocacy embodies a legacy of excellence and dedication. Born on the 30th of December 1950, Dr. Murthy's upbringing instilled in him a deep sense of intellectual curiosity and a passion for justice. His illustrious career as an advocate commenced on 18th March 1978, marking the genesis of a lifelong commitment to the pursuit of legal excellence. Dr. Murthy's academic prowess shines through his academic achievements, earning him not only a Bachelor of Commerce degree, but also a Master's degree in Arts and Law, alongside a coveted PhD. His scholarly pursuits culminated in a doctoral degree in international law in 1984, laying the foundation for his expertise in the intricacies of global legal frameworks. With a career spanning over 4 decades, Dr. Murthy has left an impressive mark on the legal landscape, advocating before the hallowed halls of Supreme Court and various high courts, and also a multitude of tribunals. His mastery extends across diverse fields of law, from taxation and constitutional matters to corporate law, enriching the legal discourse with profound insights and expertise. Beyond his legal practice, Dr. Murthy's leadership and commitment to service are exemplified by his roles as the president of the Rotary Club in Vijayawada, his tenure as the president of AP Sales Tax Bar Association, among other esteemed positions. His contribution to the legal fraternity have been recognized through a myriad of glorious awards, including the prestigious Lifetime Achievement Award presented by the Aiftp and the recent accolade bestowed upon him at the Lex Falcon Global Awards India 2024. A prolific author and speaker, Dr. Murthy has tirelessly contributed to the growth of legal education, sharing his wealth of knowledge through seminars, conferences, and scholarly publications. He authored works including books on service tax and various aspects of GST legislation, which stand as testaments to his commitment to advancing legal scholarship and education. As we gather here today, it is with great honor and admiration that I present to you my grandfather, Dr. MVK Murthy, a beacon of legal excellence whose contributions to the field continue to inspire the community. May I request Anirudh to please escort Dr. MVK Murthy onto the stage.
Please put your hands together to. This is a great moment for us. Thank you, sir. Before we proceed, we have TTP advisor, guide, mentor, and advocate, Mr. P.V. Subbarao Garu, will present the books to the honorable judges. I think these, these books are his experiences and various other people's experiences which were actually written by him. We acknowledge this on this occasion, sir, and thank you very much for sharing this valuable insights on this. Thank you, sir. Mr. PVSS Prasad is a practicing chartered accountant and an information system auditor and is a partner of Mrs. Prasad and Prasad Chartered Accountants in Hyderabad since '86. He is the past chairman of Hyderabad branch of Institute of Chartered Accountants of India. He is the past president of the AP Tax Bar Association and past chairman of International Fiscal Association Hyderabad subchapter. He is the past member of Executive Committee of International Fiscal Association India. He was a co-chairman of the Direct Taxes Committee of the Federation of Andhra Pradesh Chambers of Commerce and Industry 3 times in the past. He was co-opted member of Fiscal Laws Committee of the Institute of Chartered Accountants of India, New Delhi, and was co-opted member of Committee on Financial Markets and Investors Protection of Institute of Chartered Accountants of India. He co-authored a handbook titled Monograph of Half Taxation, published by the AP Tax Bar Association. He has authored a book titled Cash Credits, Unexplained Investments Gifts, published by All India Federation of Tax Practitioners. He has been a regular speaker and presented papers on taxation, international taxation, accounting standards, corporate governance, including transfer pricing, permanent establishment, and other key areas of international taxation, etc., at various fora. And he co-authored a book called International Taxation, a Basic Study. He is a regular faculty for the international tax courses being conducted by Institute of Chartered Accountants of India, IFA. He has contributed several articles on corporate taxation, cross-border taxation, transfer pricing, permanent establishment, and a lot. He was appointed as one of the branch reporters of IFA Congress that was held in Rome, Italy on the subject. He was the chairman of All India Federation of Tax Practitioners, South Zone for the term 2010 and 2011. He was invited to speak at IFA Asia Conference as well. He was nominated as special invitee in the Committee of Taxation, New Delhi. He was co-opted as member Committee of International Taxation. He was invited as a panelist at Asia Pacific Regional Tax and member of Committee on International Taxation. He was elected vice chairman on International Fiscal Association India branch. He is elected as chairman of IFA India branch on the term 23 and 25. May I request, put your hands together to welcome Prasad on the stage, please.
Congratulations, sir. May we now request the honorable judges to present a memento to Srimati Lakshmi Srinivas, the cultural program artist who performed the Veena for us today. Thank you for your beautiful performance, ma'am. Ma'am is also the wife of the South Zone chairman. So congratulations, ma'am, and also to sir for witnessing this beautiful performance.
And she needs a bigger applause. I think she had given a very good entertainment. She's a very good violinist. We have seen her in the morning. A little louder, please. Thank you. Thank you, ma'am. Ladies, balan takku undi kada ikkada andukani gettiga marokkasari. Thank you, and another person to felicitate, Mr. Kabraji. He served as a treasurer, joint secretary, and vice president of Aiftp. RBI nominated as a director of AP Mahesh Urban Cooperative Bank, having 45 branches of this bank. And he's a secretary of MSS Law College and MSS LLM College, Lions Club of Hyderabad, Sadhuram High Hospital, KTR College of Pharmacy of Commerce, treasurer of Hindi Mahavidyalaya Autonomous College, having PG and degree courses, Hyderabad Children's Aid Society Limited, on the board of State Government Telangana, 2 ITI colleges, of which 1 chairman of Finance Committee, and he is a joint secretary of TRG College of Management MBA, S. Sharma College of MSc Maths, SR Patwani College, and RK Sabu College, and he is a correspondent of the DR Jindal Junior College, GR Singhvi Jain Junior College, Heder Modern High School, received number of appreciation certificates and mementos from various trusts, clubs, societies, companies, corporates, and also life member of number of institutions and trusts. And he is on board of 8 institutions and enterprises. May we welcome Kabraji on this occasion, yeah. Yeah, thank you.
Congratulations, sir. We now felicitate Mr. Bhaskar Reddy Garu. Mr. Bhaskar Reddy was born on 9th December 1962 and hails from Vijayawada of Krishna district. His father, late Sri V. Satyanarayan Reddy, was a veteran freedom fighter. Mr. Bhaskar Reddy completed his graduation, BSc, in 1982 from Siddhartha College, affiliated to Nagarjuna University, and BL in the year 1987 from the Andhra University. He got enrolled as an advocate on 19 June 1987 and has been regularly practicing before the High Court since then. He joined the chambers of late Justice Sri S. Rama Reddy, a leading tax practitioner in the year 1987. He was also appointed as the Assistant Government Pleader in the year 1993 and represented the government for the departments of Mines and Geology, GAD, Irrigation and Home. In the year 1994, he was attached to the Advocate General's office and assisted the Advocate General in various matters, including the matters filed under the Representation of Peoples Act 1950. Congratulations, sir. We'd now like to felicitate Advocate P.L. Narasimham Garu. Narasimham Garu was born in '62 in Hyderabad. His education is in BCom LLB from Osmania University, and he has been practicing since 1998. We also request Ms. Bhanu to please join him on stage. He was also the founder secretary of Ttpa and has served 2 times, once as a president and vice president. He is blessed with wife, Bhanu. Ms. Bhanu also very affectionately wrote he's blessed with 1 wife only in the message. Ms. Bhanu is also the MC, and she is working in pharma as a head quality for India. He has 2 sons who are married, along with a 3rd son, and his ma'am has taken the memento. Congratulations, ma'am. He's also served as a Lions Club president and as a member since 2 decades and has served the community relentlessly since then. Congratulations, ma'am and sir, especially to you on having only 1 wife today, who's the MC. Thank you.
And his 3rd son is a pet, he's a Labrador, so he is more affectionate than the children. May I now take the opportunity to introduce Mr. Ghanshyam Upadhyay. Mr. Ghanshyam Upadhyay is a renowned consultant and educationist in the field of tax matters. He is a registered GST practitioner practicing indirect and indirect tax laws. He is providing tax consulting to business community for more than 28 years. Fraternity benefited a lot from his publications. Apart from providing consultancy services, he is also actively associated with various tax forums like Telangana Tax Practitioner Association, AP Telangana Tax Bar Association, and All India Federation Tax Practitioners. In addition to the above activities, he is also a member of Authors Guild of India and Rajasthani Graduates Association. He has authored many books on goods and service tax, Telangana, AP, value-added tax, including its first Hindi edition, and has been actively guiding and writing books on various tax laws. His latest publication is GST Rate Finders on Goods, a ready reckoner for goods arranged in alphabetical method, along with 7 other ready reckoners. And we welcome him and we honor today. Thank you. Thank you, Upadhyay Garu. And next we have Burgula Durga Prasad Rao Garu. We welcome him on the stage. Burgula Durga Prasad Rao Garu has born in '65. He has completed BCom graduation in '86. He has started the practice under the name of Prasad & Co. in Khammam. He has 37 plus years of post-qualification experience in both direct and indirect tax laws. He is the president of Khammam District, the GST Professionals Association during the year 2019 to 22, and at present he is honorary president of the association, vice president too of Telangana Tax Practitioners Association, Hyderabad for the term 23 to 25. Congratulations.
Thank you, honorable judges. Last but not the least, one of the men behind bringing all the 3 associations and providing the infrastructure and hall free of cost, Mr. Nitin Parekh. Sir, we invite you onto the dais. Thank you, sir, for being so gracious. We'd like to once again congratulate everybody who has been felicitated today. Your contributions to this field are remarkable and are not going unnoticed.
Please put on your hands together. Once again, congratulations to all of them who have received and who have not yet received, but still you have contributed a lot to the society and to the community. Thank you. Now it's a time to honor the honorable judges. So, can we have Dr. M.V.K. Murthy, National President Narayan P. Jain, and M. Bhattad, all of them onto the stage to honor the Supreme Court judge, please.
We call upon you all to please honor our chief guest for today, Justice Ujjwal Bhuyan, Judge at Supreme Court of India. Thank you, sir, for taking time out of your busy schedule and flying all the way from Delhi for this conference specifically. May I also request President of TTPA, Kumar Garu, and also the Chairman of Aiftp South Zone to please honor our guest of honor for today, Honorable Justice Alok Aradhe, Chief Justice of the High Court of Telangana as well.
Thank you. May I request Sri Suresh Kumar Singhal, Senior Vice President of FTCCI, Sri R. Ravikumar Garu, Vice President of FTCCI, Sri Anil Agarwal Garu, Immediate Past President of FTCCI, to come on to the stage to felicitate the judges, please. Can we have a big round of applause, please? I think it's nearing lunchtime. We still have the energy of breakfast, right? Thank you. Let me take this opportunity to introduce guest of honor, Mr. Justice Alok Aradhe. He was born on 13th April 1964 at Raipur, BSc, and he has completed his BSc and LLB. He is enrolled as an advocate on July 12, 1988. He is designated as senior advocate in April 2007. He was instrumental in revising the 5th and 6th editions of Principles of Administrative Law by MP Jain and SN Jain with the late Honorable Justice G.P. Singh, Chief Justice of High Court of Madhya Pradesh. He was a visiting faculty in Judicial Officers Training and Research Institute to address judicial officers on various issues. He has practiced on civil and constitutional arbitration and company matters in the High Court of Madhya Pradesh at Jabalpur. He is appointed as Additional Judge of the High Court of Madhya Pradesh on 29 December 2009 and a permanent judge on 15 February 2011. He was transferred to High Court of Jammu and Kashmir on September 16, 2016 and took oath of office on 20 September 2016. He was nominated as Chairman of Jammu and Kashmir State Judicial Academy Wide High Court, appointed as an Acting Chief Justice of High Court of Jammu and Kashmir and functioned as such up to 2018. He was nominated as Executive Chairman of Jammu and Kashmir State Legal Services Authority. On transfer to Karnataka High Court, His Lordship took oath as Judge of Karnataka High Court on 17th November 2018. His Lordship assumed charge as the Acting Chief Justice of Karnataka High Court on 3rd July 2022 and functioned as such till 14th October 2022. He was elevated as the Chief Justice of Telangana High Court and sworn in on 23rd July 2023. Welcome you once again. Thank you, sir. Yeah, before we have, the next proceedings. Nagaraj. Yeah, we have a prasadam from Yadagiri Gutta.
Every time auspicious prasad from Nagaraj Garu. Thank you very much.
As we know, this is one of the important and recent developed temple in Telangana. I think who have not seen, it is a must-to visit place. May now my humble request, Honorable Sri Justice Alok Raarade, Chief Justice High Court of Telangana, to deliver his valuable message on this occasion, please.
Honorable Mr. Justice Ujjwal Bhuya, Judge Supreme Court of India and Chief Guest of today's function. He is known to be a judge who is expert in law and hardly needs any introduction to this audience. I am sure all of you practicing in Hyderabad must have got an opportunity to appear before him in tax benches as when he was Chief Justice of this court. My esteemed colleagues on the bench, Dr. Ram Raju Srinivas Rao, Chairman All India Federation of Tax Practitioners, Shri K. Narsingh Rao, President of Telangana Tax Practitioners Association, Mr. M. Jaydev, President Federation of Telangana Chambers of Commerce and Industries, Mr. M. V. K. Murthy, Advocate, members of the Tax Bar, ladies and gentlemen. It's indeed my privilege to be amongst you all on this inaugural session of the conference which is being organized by All India Federation of Tax Practitioners. I extend my greetings to each one of the distinguished delegates, experts, practitioners and professionals in the field of taxation who have come together to have a dialogue and deliberations on the matters of paramount importance. Taxation undoubtedly stands as one of the critical pillars of any civilized society. It serves as a life that fuels the machinery of governance and enables it to fulfill the obligations towards the citizens to foster the socio-economic growth. Taxation is a vast subject. Tax laws have been rapidly changing. As far as we are concerned, the famous economist Chanakya once said that tax should be collected as to how honeybee collects nectar from the flowers. In the modern era, new tax regimes have come and government is implementing new taxation schemes due to which the country is marching ahead. The topics of technical sessions of the conference are interesting, and it's heartening to note that these sessions are interactive also. Let us take this opportunity to engage in the effective exchange of ideas and make an endeavor to harness the collective wisdom and experience of this assembly to navigate the intricate contours of taxation. As we embark upon the journey of enlightenment, let us reaffirm our commitment to the noble cause of advancing the public good to reasonable and responsible practice in the field of litigation. I am sure that efforts will be made to explore the innovative strategies for advancing transparency, efficiency, and fairness in tax administration. I take this opportunity to thank the organizers, sponsors, and participants who have made this conference possible. Thank you.
Thank you, sir. We now recognize the presence of Sri Suresh Kumar Singhal, Senior Vice President of FTCCI. We welcome you, sir.
Ladies and gentlemen, it is with great pleasure and pride that I introduce to you a remarkable individual whose dedication to the legal field has not only elevated him to the esteemed position of a Supreme Court judge, but has also left an indelible mark on the landscape of justice in our nation. Born on 2nd August 1964 in the vibrant city of Guwahati, Born on 2nd of August 1964 in the vibrant city of Guwahati, Justice Sri Ujjwal Bhuyan's journey in the legal realm began with a profound influence from his father, late Suchendranath Bhuyan, a distinguished senior advocate and former Advocate General of Assam. Nurtured by a legacy of legal brilliance, Justice Bhuyan embarked on his legal educational odyssey at Don Bosco High School, Guwahati, and later honed his intellect at Cotton College, where his passion for law began to blossom. Fueling his intellectual curiosity, he pursued a bachelor's degree in arts from Kirori Mal College, Delhi, before delving deeper into the intricacies of law at the Government Law College, Guwahati, where he earned his LLB degree. His quest for legal mastery led him to further academic pursuits, culminating in the acquisition of an LLM degree from Guwahati University, Guwahati. Justice Bhuyan's journey in the legal arena is a testament to his unwavering commitment and expertise. His tenure, spanning 16 years as a standing counsel of the Income Tax Department, starting from humble beginnings as a junior standing counsel in May 1995, showcases his steadfast dedication and invaluable contribution to the realm of taxation law. Beyond his role in tax advocacy, Justice Bhuyan's multifaceted career saw him serve as the additional government advocate for Meghalaya and a special counsel for the Forest Department of Arunachal Pradesh, demonstrating his versatility and breadth of legal acumen. His illustrious career path led him to the prestigious Guwahati High Court, where he served as standing counsel before ascending to the role of additional judge in October 2011, marking a pivotal moment in his judicial journey. Justice Bhuyan's commitment to legal education and reform is underscored by his pivotal roles at the Mizoram State Legal Services Authority, the Judicial Academy of Assam, and the National Law University, Guwahati, where his guidance and expertise have shaped the minds of future legal luminaries. In 2019, Justice Bhuyan's judicial prowess earned him a transfer to the Bombay High Court, where he continued to dispense justice with unwavering integrity and diligence. Subsequently, his journey led him to the Telangana High Court, where he assumed the mantle of Chief Justice, leaving an indelible mark on the legal landscape of the state. On 14th of July 2023, Justice Ujjwal Bhuyan's exemplary track record and unwavering commitment to justice were recognized by the Supreme Court Collegium, culminating in his elevation as the Judge of Supreme Court India, and also a testament to his tireless dedication and unparalleled legal expertise. From notable judgments such as the judgment on the Bilkis Bano case to striking down the Telangana Eunuchs Act as unconstitutional, Justice Bhuyan has been a luminary in the legal field. Justice Bhuyan, also a member of AIFTP, has been at the forefront of spearheading tax laws in India. Justice Bhuyan's recent judgments observing that deduction ought to be computed under Section 80IA of the Income Tax Act must be in accordance with the market value of electricity, which is at the rate at which the state board supplies power, and also that tax returns filed without regular books of account are not invalid, and that the burden to call for curing defects is on the assessing officer are further illustrations of his excellence. With each step of his remarkable journey, Justice Bhuyan's effort to increase legal awareness and access to justice have only soared, as evident from his numerous engagements and insightful discussions on pivotal legislation such as the Prevention of Money Laundering Act, taxation laws, arbitration and conciliation acts, amongst many others. It is my honor to invite Justice Ujjwal Bhuyan to share his invaluable insights and experiences with us today at the National Tax Conference as we collectively strive towards a more equitable and just society under the guiding light of his wisdom and expertise.
My esteemed brother, the very hardworking, very knowledgeable, and very erudite Chief Justice of the High Court for the state of Telangana, Justice Alok Aradhe, my distinguished former colleagues of the High Court for the state of Telangana, Justice Tukaramji, Justice Bhaskar Reddy, and Justice J. Anil Kumar, the President of the All India Federation, all the distinguished office bearers on the dais, Mr. B. Narasimha Sharma, the Additional Solicitor General of India, distinguished senior advocates, advocates of the High Court who are present here, very familiar faces I see, Mr. Murthy, Mr. Subbarao, and all the distinguished guests and participants who have joined here today, being present here today, not only from the city of Hyderabad, but from the districts and other parts of the country. A very good morning to all of you. It always happens with me, I prepare my speech, I write good morning, but by the time my turn comes, it becomes good afternoon. But today it is still 20 minutes, and thank you for inviting me. Since you have invited me, I have come all the way from Delhi. I must justify my presence, but don't be apprehensive. I won't take much time. The watch there actually should have been there so that the speaker can see the watch and accordingly mold his speech. I have to look behind and then. Please, Mr. Parikh, please do that next time. Well, friends, I'm very happy to be here today. This conference has given me an opportunity to come back here, and I'm particularly happy for two reasons. Firstly, it gives me an opportunity to be in the midst of tax practitioners. I share a special bond with the tax practitioners going back to my lawyering days. In fact, I was a life member of the All India Federation of Tax Practitioners. And the federation actually, when I became a judge in 2012, in the conference in Guwahati, which was attended by the then Chief Justice Altamas Kabir, the federation had felicitated me on my elevation as a judge. I was present there in the conference again in Guwahati, and then in 2019, I was present in the Bombay conference, where, as Mr. Jani had pointed out, I had administered oath to the incoming office bearers of the federation. I think Nikita Badheka was the president at that point of time, if I recollect correctly. So this is one reason why I'm very happy to be in this conference. Secondly, attending this conference gives me one more opportunity to come back here to Hyderabad. I had a very fulfilling tenure, both as a Puini judge and also as a Chief Justice of the High Court for the state of Telangana, the people of the state as well as of the city, and more particularly the legal fraternity. They were very kind to me and my family. Therefore, coming to Hyderabad is always like a homecoming for me. So, many thanks to the organizers for giving me this one more opportunity to be back in Hyderabad. I shared the bench for a long time with Justice Bhaskar Reddy. That Vijay Mogli's judgment, it was co-authored. Our bench had delivered the judgment. Thereafter, I stayed with Justice Tukaramji for a long time. Justice Anil became a judge after I left here, so I did not have the opportunity to sit with him. So, Mr. Sarfaraz is present here, the PPS to the Chief Justice. He had managed the office of the Chief Justice in a very immaculate way, in a very, very disciplined way, making the work of the Chief Justice that much more comfortable. Friends, as I can see from the program schedule, there are 2 working sessions here. The subjects you all know. I'm not going to deal on these subjects. It will be dealt with by the experts, by the resource persons who are here. But I thought I should flag off 2 issues which I think are very relevant and contemporary, and also relates to the second topic of discussion, that is the input tax credit. I would like to highlight the provision relating to arrest. One of the speakers had pointed out regarding arrest under section 69 of the CGST Act, and also the corresponding state legislations, and the provision relating to provisional attachment of property including bank accounts under section 83. Because these provisions are in the news, are nowadays being invoked quite frequently, and the courts are being approached by the litigants in this regard. Well, friends, subsection 1 of section 69 says that where the commissioner has reasons to believe that a person has committed any offense as specified in subsection 1 of section 132, which is punishable under clauses small I and II of subsection 1 or subsection 2, he may by an order authorize any officer of central tax to arrest such a person. The word is may, so it is not that he has to arrest. Pausing for a moment, what is noticeable is that first and foremost, the commissioner must form a reason to believe that a person has committed an offense under section 132(1) of the CGST Act and punishable under subsections 1 and 2 of the said provision. Secondly, if he forms such a reason to believe, then he may pass an order authorizing any officer of central tax to arrest such a person. Well, I may point out that while punishment under section 132 is graded, it is graded for different breaches, the maximum sentence is on conviction is 5 years. As I said, the crucial expression is reason to believe. This expression is, however, not defined in the CGST Act, but is an expression you will find in many taxing and penal statutes. The expression has received considerable judicial attention. In the context of reopening of assessment under the old Indian Income Tax Act 1922, Supreme Court in the famous case of Calcutta Discount Company versus Income Tax Officer in 1960 itself had held that the income tax officer must have reason to believe that income had escaped assessment before he could proceed to reopen a concluded assessment. There must be a live link between the reasons recorded, which must be on the basis of the materials gathered, and the formation of belief that income chargeable to tax had escaped assessment. Such reason to believe must therefore be germane to the issue and must not be fanciful. Reason to believe cannot be equated with reason to suspect. In Tata Chemicals Limited versus Commissioner of Customs, a two-judge bench of the Supreme Court examined expressions such as deems it necessary, reason to believe, so on and so forth, and observed that these expressions have been held not to mean the subjective satisfaction of the officer concerned. Such power given to the officer concerned is not an arbitrary power and has to be exercised in accordance with the restraints imposed by law. A division bench of the Bombay High Court, headed by me, had examined the expression reason to believe as appearing in section 69 of the CGST Act in a case called Daulat Samirmal Mehta versus Union of India. The bench analyzed the powers conferred upon the commissioner under section 69 of the CGST Act, holding that recording of reasons to believe by the commissioner that a person has committed an offense and is required to be arrested is the sine qua non for exercise of that power. It has been held that the requirement under subsection 1 of section 69 is recording of reasons, not only that a person has committed an offense as specified, but additionally as to why such person needs to be arrested. Mere infringement or mere violation of law would not empower the commissioner to authorize arrest of a person. He must record reasons why he should be arrested. Daulat Samirmal Mehta highlighted that CGST Act is primarily an enactment for collection of revenue, which is its primary objective. Arrest is only incidental to achieve the said objective. The bench went on to hold that the commissioner must also record the necessity for arresting such a person when that person had complied with the summons while granting bail to the petitioners. In Daulat Samirmal Mehta, the bench observed that bail jurisprudence, which has evolved over the years, stands on a different footing altogether, whether it is in the case of CGST or PMLA. Bail jurisprudence stands on a different footing altogether. When we talk of bail, I am reminded of the Constitution Bench judgment of the Supreme Court in Gurbakh Singh Sibia versus State of Punjab, reiterating that bail is not to be withheld as a punishment. The process cannot be the punishment. Justice Krishna Iyer had famously said, and I quote, "The issue of bail is one of liberty, justice, public safety, and burden of the public treasury, all of which must insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process." Supreme Court reiterated that Article 21 is the Ark of the Covenant so far as fundamental rights are concerned. Though our Constitution has no due process clause as in the American Constitution, nor the 8th Amendment, when it comes to the question of right to life and personal liberty of the citizens of India, following the law laid down by the Supreme Court in Cooper and again in Menka Gandhi, the consequence is the same. Though we may not have written due process, the consequence is the same. Now, reverting back to section 69, subsection 2 says that when a person is arrested under subsection 1, the officer authorized to arrest the person shall inform such person of the grounds of arrest and produce him before a magistrate within 24 hours. subsection 1, the word used is may. It is discretionary whether to arrest or not to arrest. But once you arrest, the requirement to furnish reasons of arrest, the grounds for arrest, is mandatory. That's why the reason the word used is shall. Now subsection 3 says that the provision for bail is subject to the provisions of the CRPC. A person arrested under subsection 1, again the word used is shall, be admitted to bail or in default of bail be forwarded to the custody of the magistrate. Clause B says that in the case of non-cognizable and bailable offence, the Deputy Commissioner or the Assistant Commissioner shall, for the purpose of releasing an arrested person on bail or otherwise, have the same powers and are subject to the same provisions as an officer in charge of a police station. According to me, the use of the word shall in subsection 3 is quite significant. Having regard to the maximum duration of sentence upon conviction and considering the fact that CGST is primarily a revenue legislation and not a penal statute, the legislative intent appears to be that in the event of breach of section 132(1), the person arrested is ordinarily to be granted bail. They can't be, otherwise the legislature would not have used the word shall. Now when we delivered the judgment in Daulat Samirmal Mehta, no high court in the country were granting bail to persons arrested under this provision of CGST. In fact, one judgment from Telangana, the Andhra High Court here, just authored by Justice Ram Subramanian, that was in the context of anticipatory bail. The bench had declined to grant anticipatory bail, though anticipatory bail is nothing but a facet of bail. So therefore, to be on the safer side, in Daulat Samirmal Mehta, while granting bail under 226, we had imposed certain conditions. They said that he was responsible for this input tax credit, evasion of so and so to the tune of 9 crores or something. So we said that on release he will deposit 1 crore or something. CGST, the revenue had filed SLP before the Supreme Court. Supreme Court not only dismissed the SLP of the revenue, but that particular condition which we had imposed, that he should deposit certain amount, that was set aside by the Supreme Court. So this is where we stand insofar. Then again, arrest is concerned. Then again, if you look at the appellate provision, section 107, it is another matter that we don't have appellate tribunals constituted. So a lot of writ petitions are being filed because of non-establishment of appellate tribunal. But if you look at the appellate provision 107, subsection 6 says that for filing an appeal, you have to pay the admitted amount in full and 10% of the disputed amount. So once you pay this admitted amount in full and 10% of the disputed amount, under subsection 7, there is automatic stay. There is automatic stay. It says that there shall be no coercive action against the appellant. If this is the position post adjudication, when we have the quantification of the tax due, to arrest a person prior to quantification on the allegation that he is responsible for evading GST for this amount and not granting him bail, well, this is therefore, we thought that we should pass that order. We passed that order, and thereafter a number of high courts have passed this order. Of course, while granting bail, certainly the petitioner can be put to terms and conditions that you pay so and so amount while granting bail. So, in fact, this is the contention which was raised in C. Pradeep versus Commissioner of GST, and Supreme Court had accepted this condition and granted interim protection to the petitioner, saying that no coercive steps should be taken. As Chief Justice of the Telangana High Court, a division bench headed by me in Agarwal Foundries Private Limited versus Union of India, found in the facts of that case that investigation was going on and on. Petitioners being taxable persons under GST, we said that they were required to cooperate with the investigation. While the GST authorities are empowered to investigate alleged GST evasion, such investigation cannot be for an indefinite period. It can't go on and on and on. At one point of time, it has to come to an end, whereafter an appropriate order may be passed by the adjudicating authority if the materials on record justify passing of such an order. It was in that context the bench had observed that the demand was still to be adjudicated upon. If the demand was adjudicated upon, then the petitioners would have the right to file appeal under section 107. And if the petitioners file an appeal and deposit the amount under subsection 6, there would be automatic stay under subsection 7. So this is the principle, and as I said, bail is something which is central to our constitutional jurisprudence. It strikes at the very liberty of a person. Therefore, and CGST is a revenue legislation, primarily a revenue legislation. It's not meant for incarcerating people for a long period. It is only an enabling provision, a weapon in the hands of the revenue to ensure that there is some deterrence and the taxes are paid by the concerned authorities. I'll come to this aspect a little later. Now, 83 also, prior to its amendment, very recently it has undergone an amendment. Prior to the amendment, it said that if certain proceedings are pending under 62, 63, 67, like that, and if the commissioner is of the opinion that for the purpose of protecting the interest of the government revenue, it is necessary so to do, he may by an order in writing attach provisionally any property of the taxable person, including bank account. Now in AJE India Private Limited versus Union of India, a bench headed by me in Bombay had examined this provision prior to amendment, and we had observed that invoking subsection 1 of section 83, there had to be pendency of any proceeding under these particular sections. Thereafter, the commissioner should form an opinion that for the purpose of protecting the interest of the government revenue, it is necessary to provisionally attach any property, including bank accounts of the taxable persons. Section 83 speaks of provisional attachment of any property, including bank account. In the facts of that case, it was found that the record was silent as to whether any attempt was made for provisional attachment of any property other than the bank accounts, and why the bank accounts only should be attached. The use of the word may in subsection 1 of section 83 is indicative of the legislative intent that exercise of such a power is discretionary. Thereafter, the bench held that when discretion is vested in an authority, such discretion has to be exercised in a just and judicious manner. More so when the power conferred under section 83 admittedly is a very drastic power having serious ramifications. Such power having the potential to adversely affect property rights of persons as well as life and liberty under Article 21 of the Constitution of India has to be exercised in a fair and reasonable manner. I remember one judgment from the Gujarat High Court. They said that don't use this power in such a manner that it cripples the entire business activity of the taxable person, and that he becomes crippled and unable to pay any dues to the department. Being possessed of power is one thing, and exercise of such power is altogether another thing. Because the commissioner is conferred with the power of provisional attachment under section 83, it would not ipso facto mean that he can straight away proceed to automatically provisionally attach any property including bank accounts of a taxable person merely on the ground of pendency of a proceeding. In the context of section 110 subsection 5 of the Customs Act, where there is a similar provision for provisional attachment, again a division bench in the Bombay High Court, headed by me, in Good Matric Export Private Limited, had examined the concept of provisional attachment. We all know provisional means a temporary arrangement. There are two words, provisional and attachment, and if they are read in conjunction, it can only mean a temporary attachment. Black's Law Dictionary has defined provisional to mean temporary or conditional. So therefore, it means arranged or existing for the present, possibly to be changed later. Again, in the case of Praful Nanji Satra versus State of Maharashtra, a division bench of the Bombay High Court examined identical provision regarding provisional attachment of property under section 83 of the Maharashtra Goods and Services Tax Act 2017. Telangana Goods and Services Act would be the same. It's all perimeter provisions. The bench observed that attachment of property including bank account of a person, even if provisional, is a serious intrusion into the private space of a person. It may lead to violation of the right to privacy, and after Puttaswamy, it is a fundamental right which is traceable to Article 21. Therefore, Section 83 has to be strictly interpreted. If the attachment of bank account is found to be without jurisdiction, the remedy of filing objection, etc., under Rule 159(5), it's no bar to seek relief from a constitutional court under Article 226 of the Constitution of India. Friends, last week I was in Bombay to release a book on PMLA, authored by an advocate, Akhilesh Dubey. There also I said PMLA is a potent weapon in the hands of the Enforcement Directorate. Today, in this conference of tax practitioners, Section 69 and 83 of the CGST Act and the corresponding provisions under the State GST Act are potent weapons in the hands of the revenue. They have conferred very drastic powers in the hands of the revenue. While there is no dispute that the revenue must have all the wherewithal at its command to fight tax evasion, but given the drastic nature of the two provisions, there should be no arbitrariness and there should be no discrimination in the application of these two provisions. It is equally true that stiffer a provision is, the stricter would be the judicial scrutiny. These two provisions are potent weapons in the hands of the revenue. Therefore, the said provision should be carefully and sparingly used. We all know that a weapon loses its potency if it is overexposed or over-applied. If that happens, there may be a negative perception about the actions of the authority, in which event it is the community, after all, it is the community which will suffer. We hope and trust that all the stakeholders will apply the law in its true spirit, having regard to the objective of the GST legislations and keeping in mind the overarching constitutional mandate of Article 21 of the Constitution. I would not continue further. Thank you very much for inviting me. My best wishes to the organizers and to the participants. Thank you very much, and God bless.
Thank you, Lordship, for such an enlightening and detailed analytical speech. May I now request the honorable judges, especially the chief guest, Honorable Justice Mr. Ujjwal Bhuyan, to please help us release the e-souvenir for the conference today. Congratulations to everybody who's attended the conference and also the organizers. May we now request the TTPA Governing Council to please come onto the dais for the picture. We'd also like to request Sri Suresh Kumar Singhal, Senior Vice President FTCCI, and Sri R. Ravi Kumar, Vice President FTCCI, to please head on to the dais. We request you to please join for the picture. Mr. Nitin K. Parekh, we also request you to please head on to the dais, sir. Thank you, everyone. May I now request Secretary AIFTP South Zone, Sri Chakra Ramanagaru, to please hand over the vote of thanks.
Good afternoon, all the delegates. Good afternoon to the dignitaries on the dais and off the dais. Small change is there. Mementos would like to award to the Master of Ceremonies.
Master of Ceremony, Shivangi Garu, thank you very much. And Banu Garu, thank you very much for conducting this special program.
Good afternoon to the dignitaries on the dais and off the dais, one and all by name who have come from all the places of the zone and across the country. Thanks to His Lordship, Honorable Sri Justice Ujjwal Bhuyan, Judge Supreme Court of India, for accepting and consenting to be the chief guest for today's program, and also thanks to His Lordship, Honorable Sri Justice Alok Aradhe, Chief Justice, High Court of Telangana, for accepting and consenting to be the guest of honor to grace today's
program despite their busy schedule. Thanks to the AFTP National President, Sri Narayan P. Jain, Advocate, and also thanks to the AFTP National Deputy President, Sri Samir Jani, Advocate, for your great support to the South Zone. Thanks to the Telangana Tax Practitioners Association, President Sri K. Narasimha Rao and his entire team for extending contribution and great support for the organizing this grand occasion. Thanks to the President of the Federation of Telangana Chamber of Commerce and Industries Hyderabad, Sri Mela Jaydev Garu, and his entire team for extending their great support to our AFTP South Zone. It's my pride to be the Secretary of the Zone for 24 and get an opportunity to work with our beloved Chairman, Sri Ramaraju Srinivasarao Garu, and my special thanks to him for giving me this opportunity. Thanks to all members of the respective associations, print media, and the Master of Ceremony, and one and all, thank you very much. Thank you. Thank you, sir. Thank you.
Hello. I request all delegates join for tea. Ground 4. I request all dignitaries. Ground 4. Please assemble at ground 4. Tea break.
ఛాంబర్ ఆఫ్ కామర్స్ అండ్ ఇండస్ట్రీ మేము ముగ్గురం కలిసి ఈరోజు సంయుక్తంగా ఈ వన్ డే సెమినార్ని ఏర్పాటు చేయడం జరిగింది. ఈ సెమినార్ యొక్క ముఖ్య ఉద్దేశం మా సభ్యులందరికీ కూడా నూతన చట్టాల మీద, చట్టంలో వస్తున్న మార్పుల మీద ఎలాంటి అవగాహన కల్పించాలి, వాటిలో వచ్చిన లోతుపాతులు ఏంటి, దాని మీద ఒక డిస్కషన్ ఉంటుంది. అలానే చివరిలో క్వశ్చన్ అండ్ ఆన్సర్స్ అవర్ ఉంటుంది. అలానే ప్రాక్టీస్ ఎలా చేసుకోవాలి, మోరల్ వాల్యూస్ ఎలా మెయింటైన్ చేయాలి, ఇలాంటి దాని మీద కూడా ఉంటుంది. ఈ కార్యక్రమానికి ముఖ్య అతిథిగా శ్రీ ఉజ్వల్ భూయాన్ గారు, సుప్రీంకోర్టు జడ్జి గారు వారు రావటం జరిగింది. అలానే మన గెస్ట్ ఆఫ్ ఆనర్గా తెలంగాణ హైకోర్టు చీఫ్ జస్టిస్ అయినటువంటి అలోక్ అరాధే గారు, మా నేషనల్ ప్రెసిడెంట్ గారు, మా నేషనల్ డిప్యూటీ ప్రెసిడెంట్ గారు, వీరందరూ కూడా హాజరవటం జరిగింది. ఈ సమావేశానికి వివిధ రాష్ట్రాల నుంచి భారీ సంఖ్యలో డెలిగేట్స్ రావటం జరిగింది. ఎంతో మంచి ఉత్సాహంతో ఈ కార్యక్రమానికి అటెండ్ అయ్యారు. దీన్ని సక్సెస్ఫుల్ చేసినందుకు ప్రతి ఒక్కరికి ధన్యవాదాలు తెలియజేసుకుంటూ, ముఖ్యంగా ఈ కార్యక్రమం మొత్తం కూడా తెలంగాణ ట్యాక్స్ ప్రాక్టీషనర్స్ వారు వాళ్ళ భుజాస్కంధాల మీద వేసుకొని ఇంత గ్రాండ్.
About Rajendra Prasad sir. Talluri Rajendra Prasad, fondly known as RP in his professional and personal circles and a founder member of the firm TRP & Co. He is a member of Institute of Chartered Accountants of India and Institute of Cost and Works Accountants of India. He has 18 plus years of post-qualification experience in both direct and indirect tax laws. He is one of the most distinguished faculties for direct laws and indirect laws. He contributed several articles on taxation in leading journals which included magazines of ICAI, taxman publications, student newsletters, journals of IFA, International Fiscal Association. He is a visiting faculty of ICAI and ICWAI, Hyderabad, Vijayawada and Bengaluru. He has addressed 180 plus seminars at South India forums on direct and indirect tax laws covering the aspects like GAAR, POEM, TP provisions, PE, GST audit, GST annual returns, GST impact on healthcare industries, etc. He is currently practicing the profession through the firm TRP & Co. in Hyderabad. His areas of practice included representation before the CATA, ITAT, SESTAT on the tax matters involving direct laws and GST. Thank you all, and I thank Nagesh Rangi sir, NTC Chairman and TTP President Nagesh Narasimha Rao sir for giving this opportunity to give introduction about Rajendra Prasad sir. Thank you everyone.
Sir, you can start. I request you can start your session, sir. Just.
Good afternoon. Okay, meanwhile they arrange the PPT. Good afternoon to all of you. So today first we will spend a few minutes on understanding 43B clause H. Okay, very 5 or 6 points I will touch upon. Okay, then okay. So today we will first understand the provisions of 43BH, and after that the nitty-gritties of the amended version of section 147 to 153. But rest assured, I don't encroach your lunch time, but definitely I will give key and valuable insights in understanding the new scheme of taxation given of reassessment, covering 147 to 153. Okay, so coming to 43B clause H, see, as all of us know, 43B talks about there are certain expenses which will be allowed. They are given a list of expenses which are generally allowed subject to payment. And there, what do you mean by payment? So payment within the due date for filing the return of income, if it is a current year expenditure, okay, or within the same financial year. Okay, so in the expenses incurred by procuring the goods or services from MSME sector vendors. So in simple terms, your client is buying the goods or services or availing any other facility from MSME vendor, then you have to adhere to the timelines given under the MSME Act. If you are not adhering to, then what happens? Then in such a case, it will be disallowed as an expenditure and it will be allowed upon actual payment. So unlike other subclauses of 43B, this subclause doesn't have the payment up to the due date for filing the return of income. So it simply says that you pay within the time given under that particular section of the MSME Act. Then only it will be allowed as a deduction. Otherwise, it will be allowed a deduction in the year of actual payment. So what is the time limit within which we have to pay according to MSME Act? So it talks about where there is an implied or express arrangement or agreement, then in such a case, you have to honor the bill within a period of according to that agreement or according to the agreement between you and the vendor, in which case it should not exceed 45 days. On the other hand, the bill is to be honored within a period of 15 days. If you fail to do this one, then it will be first disallowed. Then later on, it will be allowed on actual payment. Let us take a very, very simple example. After that, we move on to 147, the core topic of today. By the time it will be ready, PPT will be ready. Okay. So what they are talking about is, suppose you procured from a MSME vendor and in the invoice, the vendor has given a bill saying that, sir, the invoice is to be discharged within a period of 30 days. Otherwise, interest will be attracted. It is treated as an implied agreement between you and the vendor. So the time stipulated is 30 days. So in no case, the agreed time should never exceed 45 days. Suppose the agreement says that it is 60 days, then it will be read as if it is 45 days only. So in our example, it is 30 days. So you procure the goods in the month of February. February 1st you procure the goods. Then you have to discharge within 30 days. Assuming that you discharged on March 20th, it means exactly on the 50th day. Then what are the tax implications? First, it will be disallowed. Why it is disallowed? Because you have not adhered to the timelines agreed with the MSME vendor. Then it will be allowed in the year of payment. When you paid in the same year, that's why it will be allowed. So, first disallowance is attracted, and since you have paid before the end of the previous year, it is actually allowed. So, next, suppose there is no implied or express agreement, then you have to discharge the bill within a period of 15 days. Otherwise, it will be disallowed. This is the essence of 43B clause H. Then let us understand the exceptions also. There are few exceptions which are given under the MSME sector. Remember, this 43B clause H talks about payments to micro and small enterprises only. It is not talking about when you are procuring goods or services from medium enterprises. It is talking about micro and small enterprises only. First aspect. Second, in the Udyam registration, suppose the character or the character of that particular vendor is, he has been characterized as a trader, then in such a case, this 43B clause H is not applicable. So the first exception is, it is applicable only for micro and small. So automatically, medium enterprises are excluded from the scope of 43B clause H. This is the first thing. Second, where he is registered as a trader, then also this clause is not applicable. This is not applicable. Then the third one, sir, there are two disallowances. Then which disallowance will be attracted? For example, you have procured services from MSME and vendor, then you have not deducted TDS, nor you have discharged the payment. So there are two disallowances. What are the two disallowances? First, you have not complied with the TDS provision. And you are not paid to him within 45 days or 15 days or whatever. You assume that you have never paid to that person. Then 43B clause H says that 100% of the expenditure is disallowed. Whereas 40A clause 1A, what it talks about, where you have not deducted TDS, assuming that he is a resident vendor, then what happens? 30% of the expenditure will be disallowed. Then, sir, what will be the logical answer? Whether I need to make a disallowance of 30% under 40A clause 1A and 100% under 43B, or 30% under 40A clause 1A, 70% under this one, or 0 with regard to TDS and 100% under 43B clause H. Let us understand for a logical conclusion. So the logical conclusion is, my view is 30% is disallowed under 40A clause 1A because the first disallowance is attracted under 40A 1A only. Reason is, so TDS at what point of time it will be attracted? At the time of credit or payment, whichever is earlier. So the moment there is a credit and you have to deduct the TDS, you are not done. So the disallowance is already triggered. So 40A 1A is triggered, 30% is out. Remaining 70% will be disallowed under 43BH. Yeah, so you can come to this conclusion through another analogy also. 43B, if you read, the opening of wordings of the section says that, notwithstanding anything contained in so and so other sections, where an expenditure is otherwise allowable under the IT Act. So first you need to examine what is the allowable expenditure. So out of this 100 rupees expenditure, 30% is already disallowed under some other section. So 70 rupees is disallowed. So 70% became otherwise allowable. That's why that has to be disallowed under 43B clause H. So these are the three things which I want to share so far as MSME. Then the last one, sir, many people are thinking that, sir, it will be acting as a counter. Normally what we are feeling is, sir, in order to encourage the vendors to make payment to the MSME vendors, this provision has been introduced. Now many people are saying that, sir, we will deregister from MSME because this is a very cumbersome provision which we have to comply with. So why we have to buy only from MSME? Let us buy from various other sectors. Let me buy from a big vendor. Why I should buy from MSME vendor? Like that the people are thinking, but the motto of this provision is, honestly telling, see, MSME vendors, majority of their payments, okay, their dues are arising from government departments. Their dues are arising from government departments. For example, okay, you take any government department in Hyderabad, you take any government department in entire India. So there, according to the government norms, some of the bills, some of the services, some of the goods, they have to procure only from MSME sector. Then they avail the services, they purchase the goods. But coming to the payment part, they say that we did not receive the budget from the state government or central government. Please wait. So how long we have to wait? 1 year, 2 years, 3 years. I have been advisor for one of the government departments where we have been seeing there are delays. There are delays. So to encourage or to discipline the government departments so that they make the payments to MSME sector in time, this provision has been introduced. Okay, but at the same time, others like genuine vendors, genuine associates like our clients are also getting affected. So this is the objective. Now, let us move on to the core topic of today, that is 147. Before I proceed further, yes. So, sir will give just concluding remarks with regard to 43BH, then we will start 147.
Good afternoon to everyone. It gives me great pleasure to stand before you, and I thank the Aiftp, Ttpa and FTCCI for giving me an opportunity to chair the session for direct access. And very important topics, burning topics you can call, because this 43BH has attained its heat since January only. It was not taken to attention when it was passed by the budget. When the time is nearing only, when the due date comes only, the heat picks up. So like that, from January onwards, the total business community is in utter chaos because of this section. It was neither noticed nor given attention. It deserved to understand the nuances of it and its resultant impact. Due to its peculiar nature as compared to its existing brethren sections, brethren clauses, which allows time for payment up to due date for filing the return, this stands out as a section coming into force as on the closing date, with the calculations on to reckon the defaults in payments and disallowance. And this provision is in total parallel to the accrual system of accounting, and its monitoring and impact on business industries is already felt by the entrepreneurs now. Because lot of people have started stressing for payment. Once they come to know about this section, they are registering immediately and asking for payment. Previously, people were not aware. The main purpose was to help micro and small units. But in turn, it has become, instead of becoming a bliss, that's why welcome bliss are a bane. That means it has become a bane to the industry. Because all the traders are worst affected because of this. Because all their manufacturers are seeking payment, and the people who are not registered also now registered, and they are asking that I am registered under MSME, you have to make the payment within 45 days. And the pity is, now traders also are converting their registration into manufacturer. Trader, while registering, he is selecting, he is also a manufacturer. But simply registering as manufacturer will not give him right to claim. He has to prove that he has manufactured the commodity and supplied to him. Just a trader purchasing from some other person without executing anything on it has just simply sold and cannot claim this thing. So many things are happening, and most of the people, sir, we are not having any differences between supplier and the purchaser, and they give us 4 months, 5 months, 6 months credit. Now what happens? They are asking like this also. In spite of that,
for those businessmen, there's no problem. All the problems are for auditors only. Why? Because we have to see as on the closing date. We have to report, sir, we don't have any differences. Supplier is accepting. How you are bothered? We are bothered with 43BH and we have to report that in tax audit report. And if there is anything, what is the 43CD is telling? It's statement of particulars as appearing in the books of accounts. So we have to verbatim incorporate what is there in the books of account. We cannot move away from that, and we have to report whether if it is there is delay, we have to report. Once we have reported, what will happen? Disallowance will come. Now the businessman is in a jinx. When we are not having any problem, why the income tax people, third party is having problem? So like this, lot of difficulties the professionals are going to face. So lot of things, instead of helping the businessman, it has become a curse to the business community. So like this, lot of practical problems, we have already started experiencing all the professionals. Now the blame is on the professionals, stating that, sir, ये last year आया तो अभी तक क्या करे? हमारे को नहीं बताया. As though he doesn't know until we tell. So like that, I will not touch upon the situations when there is some technical glitch. That's why always whenever a person chairs a session, he will start the speech so that all the technical glitches will be sorted out. But because of anxiety to go for early lunch, ignoring the chair, they have started the session. So this is as far as 43BH is concerned. And as far as 147 and 148 is concerned from 1/4/2001, the main objective is ease of doing the business. They have reduced from 6 years to 3 years. From 6 years to 3 years. Just like a TV advertisement. For this thing, what you call it as for selling any commodity. So a person has gone to purchase a laptop. Everything he has seen, and he purchased. Subsequently, the laptop became faulty. Then he went to this thing, and the vendor told, you have purchased seeing its screensaver, but I have not guaranteed the laptop. In the same manner, we are only shown that 6 years have become 3 years, but there is a lot of confusion in it. Now, the conditions also changed. Previously, it was reason to believe. From there, it has been changed to the assessing officer should have some concrete evidence, document, or information which grows to prove that income has escaped the assessment. So their conditions also changed. Now, whether these changes are helping us or not helping us, Mr. Rajendra Prasad, today's speaker, will speak in depth, and I am very happy that I am fortunate to hear my Guru Rajendra Prasad in front of another Guru who taught me income tax when I was doing CA final, Mr. C. Suresh Garu, because always I feel, because now I am standing as a chartered accountant because of the inspiration he imbibed in me when he was teaching me income tax. And one more time I request all the members to keep their cell phones either in the off mode or silent mode. If you don't know how to keep it in silent mode, kindly ask, don't feel inferior, ask your neighbor to help you. Because all side music are coming, background music is coming, the speaker's rhythm is disturbed. Speaker wants to tell something, suddenly ting, 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 ting will come. Then his concentration is going to ting, ting, not to his brain. So I request all the people, I observed when the Chief Justice, Supreme Court Justice is speaking, we are discussing matters here, and some people are, their cell phones are ringing. It is not, we are all professionals, and we should behave like professionals. Because we should maintain the decorum, and we should have the etiquette of following the meeting etiquette. So I request all the people, my sincere request to everybody is, kindly switch off your phones or keep it in silent mode, so that the program already delayed will give you good this thing. And my one more request is, I request all the persons to wait until the speaker completes his presentation. He has covered the topic exhaustively, and in case any doubt he has not clarified, then you note it down, and there will be a question and answer session. At that time, you can ask. With these opening remarks, I close.
Thank you, Samudgar. Okay. So now coming to the core topic of today. Sir, is it audible, sir? Last. Okay. So section 147 to 153 of the IT Act, there is a lot of change which has been brought in with effect from 1/4/2021 by the Finance Act 2021. Later on 2022 Act, it made some more amendments. That's why what our written is, new scheme of taxation under 147 to 153 as it stood, as amended by the Finance Act 2023. Okay. See, first of all, as all of us know, 147 to 153, they talk about income escaping assessment, reassessment, income escaping assessment or reassessment. Okay. So the set of sections which govern them are 147 to 153. Apart from that, there is one more section, 135A also. Okay. No need to see that one. But how the mechanism of 147 to 153 or income escaping assessment starts under the amended version. The first and foremost is, if you see the earlier language, okay, as Ujjwal Bhayan sir rightly told, the earlier old wordings of 147 is where the AO has reason to believe that. Where the AO has reason to believe that. There is some prima facie evidence based on which he has recorded, yes, this is the evidence based on which I found my belief. I founded my belief. After that, I am initiating process. This is the old wordings. But the new wordings, how they have been worded. What is the starting point for invoking provisions under 147 to 153? So we call in simple terms as step 1 for understanding purpose. Okay. What is the first step? So there is some information in the possession of the assessing officer. There is some information in the possession of the assessing officer as to or suggesting that some income has escaped assessment. Some income has escaped assessment. So the first and foremost criteria is there is some information in the possession of the assessing officer that is suggesting that income has escaped assessment. Income has escaped assessment. So the moment we get a notice, or your client gets a notice, how to defend that one? How to defend that one? So these are all the remedies. Once we understand the section thoroughly, then only we know whether the department is correct or not. But, okay, first of all, what is the first step? So there has to be some information in the possession of the assessing officer that suggests that there is some income that has escaped assessment. Okay, there is information. Yes, the answer is, the test is passed. So the assessing officer is having some information which is suggesting that income has escaped assessment. Then what he will do? Directly he will go and do the assessment? No. Once he has that information in his possession, then he has to follow the procedure mandated under 148A. What is the procedure given? What is the procedure prescribed under 148A? So they are given sequential steps. You have to follow these steps compulsorily. So, sir, why there are so many steps? They are nothing but principles of natural justice have been embedded in the new scheme of taxation. So what they are talking about is, yes, do you have information in your possession which suggests that income has escaped assessment? Assessing officer says that yes. After that, once the answer is yes, what he will do? Then he will do an inquiry. So these are the steps which are mentioned under 148A. I am giving the overview, then I will quickly walk you through the presentation, as simple as that. So the next thing is, he has to make an inquiry. So can he directly do an inquiry? No. Let him take the approval of the specified authority. he has to take the prior approval of the specified authority. Prior approval of the specified authority. So remember that, understand that there are enough principles of natural justice which have been embedded in the new scheme of taxation. What it says, do you have information that is suggesting that this person has escaped, there is some income which has escaped assessment in the case of this particular assessee? The answer is yes. Then go and conduct inquiry. Sir, as an assessing officer, can I directly go and do an inquiry? No, don't do that one. Take the approval of the specified authority. Take the approval of the specified authority. Okay, sir, he has taken. Then the specified authority also concurred that yes, you go and conduct. So the first step is he will conduct an inquiry. Then after that inquiry, then he will share that. He will grant an opportunity to the assessee saying that, sir, based on AIS, based on Annual Information System. Remember, now department is 10 times ahead of us because department is taking the help of the artificial intelligence, not artificial intelligence. They are taking the information, they are collecting information from so many sources, like digital evidence they are collecting. Digital evidence they are collecting. Whereas our client gives only one bank account to us. He says that, sir, this is my account, you file the return. You file the return. But department is having 360 degrees view of this particular client. So he has a credit card, he has so many cards. Okay. Finally, department says that, yes, you made these many transactions. These many transactions. What are the sources? What are the sources? Later on he comes to us and says that, sir, you only filed my return. You only filed my return. Then we will ask, we have given only one bank statement, which it doesn't have except opening and closing balances, some interest. It doesn't have any transactions. It doesn't have any transactions. So, right. So they will give an opportunity to the assessee. So first he has done an inquiry. Then later on he is giving an opportunity to the assessee saying that he will conduct, he will grant. So he says that, yes, from the AIS, you have 10 bank accounts. In these 10 bank accounts, you have made some deposits. You have made some deposits, 50 lakh deposit each. What is the source for that one? He is granting an opportunity to you. Granting an opportunity to you. Then you make a reply. You make a reply. Yes, you reply saying that, sir, this is not my money, or whatever. Or I have enough sources for this money. How? Sir, my son is working abroad. He is sending me money in regular intervals, which is a taxed money in US or Singapore, whatever. Then with that I am making a fixed deposit. Otherwise, I may be getting some interest income. And the aggregate interest income is not exceeding the first slab. That's why I never filed the return. I never filed the return. Then he will consider. He will consider. So first of all, there is some information which is suggested that some income has escaped assessment. What is the information? There are so many FDs opened in your name. Then assessing officer will ask, what is the source? What is the source? So he is conducting an inquiry. Inquiry means through 135 he can conduct inquiry. Faceless e-verification system. He will write a letter under 133 this the information saying that yes sir, FD is opened, FD is opened, FD is opened. All these put together 1.5 crores. He will give an opportunity. What is the source? You let me know. What is the source? You let me know. Then if he is able to explain it properly, assuming that he is a genuine assessee and he has a valid source, my son has sent the money, or if he says that, then and note is saying that he got so then we told them it is a plate income. It means whatever the devotees offer in the temple, that is my source. Then immediately department asked, okay, so what is the size of the temple, where you are working, how long you have been working, what would be your earnings per annum? Earnings per annum. Are you clear on it? Yes. So remember, unless you have some, so 70 lakh justification is little challenging. Little challenging. Okay. So, okay, then immediately when we have written, sir, 6 lakhs per annum we are getting, past 10 years we accumulated, something like that, then immediately asked, if it is 6 lakhs, why you have not paid tax? Why you have not paid tax? Because why a notice should not be given under 148. So these are the 4 steps which have been given under 148A. Let me summarize quickly. First of all, there should be some information in the possession of the assessing officer that suggests that income has escaped assessment in the case of the assessee. In the case of the assessee. If the answer is yes, then in such a case, he will go and he will take the prior approval. He will take the prior approval. I will tell the exceptions also. Under what circumstances prior approval is not required also. So, generally, the procedure given under 148A is first he will take the approval, then he will conduct an inquiry. He will conduct an inquiry. After inquiry, what he will do? He will give an opportunity to you. Opportunity to you. Then, to the opportunity, what you will do? You will reply. So, that is the third step. You will reply. Then, the AO will consider all these things. Consider all the things. His inquiry, the opportunity granted, and your reply. Then based on that, he will give an order under 148AD along with 148. Along with 148. What is the order which he is giving? Sir, based on the information which I have pulled from various sources, and after considering your detailed reply, I feel that there is some income which has escaped assessment. That's why I am proceeding for the next step. That is, I am intending to issue a notice under 148. I am issuing a notice under 148. What is that 148 notice? Under 148, he will give an opportunity to you. Yes, you file return now. You file return now. As simple as that. Suppose you have valid sources. He will drop under 148AD. 148AD. Suppose you are able to explain your case properly, saying that, sir, I am a senior citizen, retired person. I am not getting any income. Whatever money, 1.5 crores FDs are there. They are nothing but my son and my daughter who are staying abroad. They send the taxed money. So these are the sources. You give their WT form or 1040, 1042, whatever forms you submit. Then you give the bank statement of their bank statements also where there is remittance, and your bank statement also. With that, your 148AD is closed, saying that I considered all the submissions. I want to drop the proceedings. I want to drop the proceedings. This is a fair case. Unfair case, where most of us are feeling now. Okay, reason is, earlier they give only one bank statement, sir. See, we also faced the same situation. He has 10 accounts. He gives only one account. He gives only one account, except it doesn't have anything opening, closing. That's it, only interest. Okay. He says that, sir, shall I claim 80 TTA also? Okay, if you want to claim. Okay. So then, if he is not a fair assessee, then what happens? Then the department is issuing a 148 notice. Sir, what is this 148 notice? What is there in the 148 notice? Simply they say that 148AD order is passed, saying that yours is a fit case for issuing a notice under 148. For issuing a notice under 148. Sir, what are the contents of that notice? Yes. So what are the contents of that notice? Audible, sir? Last. Not audible? Audible now? Yes. 8 notice. So that what it says is, you file a return of income. Sources. What are your sources? Then you file the return also. Then what happens? After 148, you replied by filing a return. Then the procedure under 147 is invoked. 147, what it says is, yes, the income will be assessed. First time you are filing. Or reassessed. It means you filed, but you have some income which has escaped. So your income is assessed or reassessed, and your losses are recomputed, deductions are recomputed, etc., etc. Now the next one. So they issued a notice under 148 asking you to file return of income. Then you file the return of income. Then what they will do after you file the return of income? They will do assessment, that is 147. That is 147. So I hope that I am clear, okay, up to this point. Sir, assessment is also over. Or there is a small thing, sir. Sir, department gave me, normally department gives 3 months time to you to file the return. How many days they will give? 3 months. Or extension is also possible at your request. At your request. So, you are filing the return within the time. If you file the return within the time given by the assessing officer or as requested by you and accepted by the assessing officer, then it will be treated as a 139 return. Where you are not filing the return within the time, he has given 3 months time. Raghu sir, he has given 3 months time. But you are filing after 3 months, 10 days. 3 months, 10 days. What is its implication? It will be treated as a return, but not a return under 139. What will happen? See, this is a reassessment. So if you file belatedly, what happens? Belated return means losses cannot be carried forward. Certain losses. I mean to say certain losses. Yes or no? For example, you claim deductions under Chapter 6A Part C, 80 H2, 80T, 80 H2, 80 T, like 80 IA, 80 IB, 80 IC, etc. For these sections, the precondition is you should have filed the return of income within time. That is 139.1. You are not filing. Then in such a case, that may be denied. So, if you file the return within the time given, then you have all rights available. If you are not filing the return within the time given, then it is not treated as a return under 139. It will be treated as some own information. It won't be treated as a 139 return. If it is not treated as a 139 return, what is the side effect? The side effect will be, you may claim it there within the time given under 139.1. Later on, your case is picked under 148. They asked you to file return one more time. This time you filed, but not within the time. You have taken lengthy time, and this stage, in such a case, in the section itself, it has been drafted. It has been given that it is not treated as a 139 return. If it is not treated as a 139 return, you are not eligible for certain deductions. Certain losses are not eligible for being carried forward. This is the side effect. Because many people asked me, sir, the department gave 3 months time, but my brother stays in USA. He has to give all the details. He came exactly after 3 months, 5 days. Now I filed the return. Then I can't do anything. Okay. Because there is a delay on your part. It is not treated as a 139 return. Okay. You file the return within time or with delay. You understood. Then the assessment will be done under 147. Right. Then the next aspect is, sir, while doing the assessment, after this I will explain little challenging, complicated aspects. Okay. So after that one, sir, he has done the assessment. At the time of assessment, which type of tax rates will be applicable? Sir, my case has been opened for 2016-17, 17-18, 18-19. Whether there is a single tax rate which will be applicable or the respective tax rates. So the income will be assessed at the respective tax rates. Tax rates. It means what are the tax rates for 16-17? So that income, the income of 16-17 will be governed by 16-17 tax rates. Income of 17-18, that will be governed by 17-18 tax rates, and 18-19 will be covered by 18-19 tax rates. So respective tax rates. Next, sir, procedure has been initiated. It means there is some income, the assessing officer has some information that has suggested that some income has escaped assessment in my case. Then they conducted inquiry with the prior approval. Then they have given an opportunity. Then they have given a reply. Then they have issued an order saying that my case is a fit for 148. They issued a notice under 148 asking me to file return of income. In response to that, I filed return. Now assessment is going on. Is there any way in which I can plead at this stage that my assessment should be dropped? The answer is again yes. You can plead under 152 saying that, sir, my income is already assessed at a higher amount. Even if you have considered this income, even if you have considered the escaped income. So if you are able to prove your case saying that, sir, I have already paid taxes on a higher amount, even after considering this amount, then in such case, the proceedings will be dropped. For example, you are opting for presumptive scheme of taxation. You already offered at 14%. You already offered at 14%. Okay. Now the assessing officer picked up your case for scrutiny and he has brought all the things. Then he is saying that, sir, there is 1 lakh rupees revenue which has not factored the computation of total income. Then you can prove that, sir, even if you consider this one, but I paid more taxes than what I am required to pay. Then in such case, that will be dropped. Okay. So this is under 152. But at the same time, remember that when you are requesting for dropping the proceedings, you have to accept once they drop. You cannot, sir, in the original assessment, there is a lot of debate between me and the assessing officer. That time he has denied ATG. I want to accept, and you have never preferred an appeal. It means you have not re-agitated the matter. Now, at the time of reopening the matter, now you are saying that, sir, you plead that the proceeding should be dropped, then the concluded items cannot be re-agitated. So that is 153 talks about time limits. After that, I will introduce little complicated areas like how long the notice has to be issued, for which years they can reopen the cases as of today, like that. Then Ashish Agarwal's case, 1/2022 instruction. But in different situations, what are the time limits for completion of the assessment? I will talk only about one thing. Okay. So when a notice has been issued under 148, okay, your case has been picked for reassessment, etc. The assessment is to be completed within a served. Notice under 148 was served. So you have to, the assessing officer has to complete the assessment within a period of 12 months from the end of the year in which the not covering. Just you remember on the plain example, normal cases. So 1 year from the 12 months from the end of the year or 1 year from the end of notice under 148 was served. By that time, the assessing officer has to complete the assessment. Okay. So these are the basics. Let me quickly summarize the basics. 147 to 153 is over. Okay. With this limited time which I have been allotted, I cut short actually at so many places. So let me repeat the simple points first. So what they are talking about is the new scheme of taxation. It starts with, what is the starting point? There should be some information in the possession. There should be some information in the possession of the assessing officer. Yes, he has information in his possession. Then what he will do? Once he has information, then he has to follow the procedure given under 148 capital A. What is the procedure given? Then first he has to conduct an inquiry. So with directly can he do an inquiry? Normally he has to take the prior approval of the specified authority before conducting an inquiry. So first step is inquiry. Then after that opportunity, then you give reply. Then after considering the reply, he will pass an order saying that your case is a fit case for 148, or he will drop the proceedings there and saying that yes, my verification suggested that there is some income escaped, but based on your reply, I am concluding that there is no escapement in your case. Then in such case he can drop. But on the other hand, if he concludes that yes, there is some income escape assessment, then he will issue a notice under 148 along with 148A D order. So what is the type of notice? That notice will give, notice is given to you asking you to file return of income. For 3 months or such extended time. Yes, you file the return. If you file within the time, it is treated as 139 return. If it is not filed within the time, it is not treated as a 139 return. So other side effects will follow, like losses may not be allowed or may not be also be allowed, etc. Then they issue notice, then you file the return. Based on that, 147 is activated. So what is 147? Assessment or reassessment, as simple as that. So based on all the information, based on the rate of income. Under the entire IT Act, there are only 2 schemes of assessment. You may have so many sections, but a broader perspective, either cooperation model, non-cooperation model. Cooperation model means 143.3. Non-cooperation means 144. 143.3 means based on the information which you are giving. 144 means you are not giving based on his best judgment. So even under also saying that I want some more information. Right. Assessment is done. Sir, what is the time limit by which assessment is to be done? Or can I plead at this stage that since subjected to tax at a higher amount, the proceeding should be dropped. Yes, you have every right. Upon proving that your income is already taxed at a higher amount, your income is already taxed at a higher amount. Okay. So you can plead, then the proceedings will be concluded. But at the time of pleading, you cannot re-agitate the concluded items. Under 153, what is the time limit for completion of the assessment? So the assessment under 147, this is the sum and substance of 147 to 153. Simple. Let us move to stage 2. Okay. You told that, or we understood that there is some information which is suggesting that the income has escaped assessment. What are the cases? The Act has defined. Now these are the 9 cases. These are the 9 cases. 5 actual cases, 4 deemed cases. 5 actual cases, 4 deemed cases. These are the... Okay. PPT, okay. So what are the 9 cases? What are the 9 cases? These are the 9 cases where it is deemed that there is some income that has escaped assessment. What are the 9 cases? 5 actual cases, 4 deemed cases. Okay, what are the actual cases? So, see what you meant deemed cases. Deemed means it is implied that there is some income which has escaped assessment. In the deemed cases, except the case of survey, they need not take the prior approval of the higher authority. So these are the 9 cases. Sir, what are the 9 cases? Anyway, since you are asking, okay. First 5 cases are RMS. Your case has been picked based on, normally we see under CAS. Your case has been picked under CAS. Like risk management strategy of the CBDT. So your case has been picked under RMS of the department. That is the first one. Or e-verification system. E-verification system under 135A. It means the AO has in possession of information based on some e-verification. It means they have issued a notice to someone else. He told that he purchased property. Then they asked from whom you purchased. He has given your name and PAN number. Then they slapped a notice to you saying that your name and everything is included. Is it correct or not? Then you say that yes, sir. Then have you paid tax or no? No, sir. Why? Normally I am not interested, sir. Okay. So that is a different answer. Okay. No, when client came and RMS. Okay. Then information is collected under 135A. E-verification system. E-verification system. It means department has automation, captured the information. Okay. Now I have seen an interesting notice which I have never seen in my life. Okay. Of 18 years. One person has incurred so much. So to credit cards. See, normally we are seeing credit cards. So the credit cards are swiped in Italy, Russia, and Romania. These 3 countries. Then the singer asked me saying that, sir, the notice, seriously, what they asked is, so you swiped your card in Italy, Romania, and other country. So you have so much of, see how you discharge the credit card. First credit card, he has sources of income. But he is a non-filer. He is saying that, no sir, I never filed. I never paid taxes also. But because of this useless system, okay, department's powerful system, my data is getting captured. Remember, that is in relation to 1617. When you are talking about time limits, we will see whether 1670 notice can be touched even as on today or not. Then that is within the time limit. I told, sir, you have to file return. Then he filed return saying that I have these incomes, I never paid taxes. Then at the time also he is crying only. So my income is this much, I will pay 10%. Presumptive rate is 8%. Asing officer has not listened. No. I am using it will be treated as unexplained cash credit. Unexplained cash credit or unexplained money, unexplained in whatever. 68, 69 ABCD has invoked. So you pay 60%, 78 tax, 10% mandatory penalty 88 plus 2016 to this period interest. Okay. Right. So information is collected by the department through RMS or e-verification scheme. These are the 2 things. Then there is an audit objection saying that your assessment completed earlier was not in accordance with the law. It means you filed, you managed it actually. You said that, oh, that one, this one. They asked several details. Finally, you confused. Asing got confused and completed the assessment. Then later on, audit objection, it has been picked by audit objection. Finally, the audit objection in there, they said that your assessment, whatever that has been completed, that is not in accordance with the provisions of the law. Then in such a case, they can reopen. The 9 cases where, this is the 9 cases, search they give combinations. Here 5, search combinations, search and survey combinations 4. In this total 9 cases, it is treated as the assessing officer is having some information which is suggesting that some income has escaped assessment. After that, he is following the procedure given under 148A to 148D. Then 148D order plus 148 notice asking you to file return of income. You file the return. After the filing return, what I told, assessment will be done. Assessment will be done. Now let us go to little complicated areas. Last 4 aspects I will cover. Then we will conclude the session after taking question and answer. Okay. The next one is, sir, now the department is issuing notices even today. They want to reopen 14, 15 cases, 15, 16, 16, 17. Now the department also issued instruction 1/2022 saying that they introduced first time a concept called travel back in time, like time machine theory. Okay, like time machine theory. Nowhere it is, in the act it is there. They used the terms. It is deemed that the notice is traveling back. Probably CBDT has that time machine in their hands. Okay. So they are saying that as if it has been issued under the amended version, you can travel back for 10 years, etc., etc. First of all, up to which period, according to the new version, they can travel. Okay. A notice under 148 can be issued up to a period of 3 years from the end of the relevant assessment year. Up to a period of 3 years from the end of the relevant assessment year. This is the new time limit. So directly they can issue notice if it is within 3 years from the end of the relevant assessment year. Then where he is intending to issue notice after the expiry of 3 years, but up to a period of 10 years from the end of the relevant assessment year, then in such case, the income escaped, which has been accumulated in the form of an asset or in the form of an expenditure or in the form of an entry in the books of account, that should be 50 lakh rupees or more. That should be 50 lakh rupees or more. Let me quickly summarize once again. A notice under 148 can be issued up to a period of 3 years from the end of the relevant assessment year. Up to a period of 3 years from the end of the relevant assessment year, no monetary limit is there. No monetary limit. Directly they have information, even 1 lakh rupee extra also they can reassess. Okay. Where they are intending to issue notice after a period of 3 years, but up to a period of 10 years from the end of the relevant assessment year, then the income escaped should be 50 lakh rupees or more. 50 lakh rupees or more. This is the time limit first of all. Then the income escaped should be either in the form of an asset, and in the previous example I told you, you purchased a property or you sold a property, you never offered the amount for capital gains. So in that year, you are the owner of the property. Or you purchased the property and you don't have any source to explain. So either it should be in the form of an asset or it should be in the form of an expenditure in relation to a transaction or event. So if your stars are not good, then they may issue a notice saying that, sir, 6 years back, you celebrated you have done your daughter's marriage at the so-and-so Sandhya Convention Center, where you have given 1 crore rupees for that event, Or you have filed of income tax return? No, sir, I never filed. Then where is the money? Where from you got the money? You please explain. Unexplained expenditure. Jayalalitha's case. Are you clear or not? Right. So either it should be in the form of an asset or it should be in the form of transaction or expenditure incurred in relation to a transaction, event or occasion, or it is in the form of an entry in the books of account. So if the income escaped assessment is rupees 50 lakhs or more, then they can travel beyond 3 years but up to a period of 10 years from the end of the assessment year. Okay. I understood monetary limit also. Then what next? What next? Then 22 and periods prior to 21-22. Let me quickly summarize. Sir, can they issue notice under the new scheme of taxation? New scheme of taxation for assessment year 21-22 and prior years. So under 149 clause 1b, 149 subsection 1 clause b, they are given with regard to assessment years 21-22 and older years, the time limit will be governed under the old provision. The time limit is governed under the old provision. What is the time limit under the old provision? Under the old provision, they can travel back only up to 6 years. New provision, 10 years. Let me summarize once again. Sir, with regard to assessment year 21-22 and older years, sir, 14-15, assessment year 14-15. Assessment year 14-15. So since it is prior to AY 21-22, it will be covered under old scheme. What is the old scheme? Under the old scheme, they can issue notice up to a period of 6 years from the end of the relevant assessment year. Assessment year 14-15 plus 6 years. It means 31/3/2021. But they have issued notice today. So you can immediately approach the writ court. Then they will quash that one, saying that the notice is beyond the jurisdiction. The notice is beyond the time limits. Okay, beyond the time limits enunciated under 149(1)(b). I hope that I am clear. So this is the essence. Okay, so the CBDT has given an instruction 1/2022 saying that they can reopen even for counting from today. It is exactly within 10 years. Exactly within 10 years. Assessment year 13-14 plus 10 years, 31/3/2024. Yes or no? Still 9 days are there. As per CBDT, they can travel back even for assessment year 13-14 even today. They introduced a terminology called, if you read the paragraph 6.1 of that instruction 1/2022, they said, they used the terminology travel back in time. So that concept is not favored by the judiciary. They held that where from you are borrowing these terms, first of all. Okay, so you can't invent. So if you want to travel back beyond 3 years, then you have to examine it will be whether it is the answer is yes according to the old provisions or not. If the answer is yes according to the old provisions, then you issue a notice. If the answer is no according to the old provisions, then don't issue notice under this section. So to that extent, assessment year 13-14, 14-15, 15-16, they cannot issue notices today. I hope that I am clear. So then the department started saying that, sir, in Ashish Agarwal case, the Supreme Court extended time limit, etc. But again, the Mumbai High Court recently in Godrej Industries Limited, they held that, see, Supreme Court using its extraordinary power under Article 142, in order to safeguard the interest of both the assessees as well as the revenue. Okay, there are 90,000 cases reopened, 9,000 writ petitions filed across the various writ courts. In order to safeguard, what they held is the notices issued between those COVID period, okay, only the 3 months, it is deemed that they have been issued under the new section. At the same time, next paragraph, the Supreme Court further held that at the same time, both of you, it means department as well as the assessee, you have your own rights preserved. Sir, what do you mean by your own rights preserved? Your own right preserved means for the assessment year 13-14, can they issue notice now? Yes, your right is preserved. It means department is issuing notice. You have your own right saying that, sir, they want to travel back beyond a period of 3 years. When they are traveling back beyond a period of 3 years, then immediately you need to examine the time limit should be according to the old time limit. The old time limit is only 6 years from the end of the relevant assessment year. AY 13-14 plus 6 year maximum time by which they should have issued notice is 31/3/2020. After that, if any notice is issued, that is bad in law. So that is the sum and summary of these 3 cases. Okay. So that is all from my side. Okay. In order to cut short, okay, I have made it very brief. Okay. So any questions we'll take after that.
If any questions are there, you are most welcome. If any person can assist in handing over the mic, it would be better. Be brief in your question. The question should not be lengthy so that we don't understand the question. Like that, it should not happen.
Good afternoon, sir. Thank you for the enlightened session. Coming to the question, my question relates to 43BH. So, in case of supplier, MSME supplier, wherein it was registered as small, and they have not upgraded their certificate, like if we see the current position, they would be basically medium, because we see the terms wherein investment in plant and machinery and turnover should be below 50 crore. So now the turnover has crossed 50 crores. I am receiving from that vendor the material, he has not upgraded
I request members to kindly sit for 5 to 10 minutes. The questions will not last for more than 10 minutes till now. More 5 minutes or 10 minutes will not harm us. My request is, some people are questioning something. It may be helpful to you. It reminds me of a small story. When Rama asked the monkeys to go in search of Sita, everybody ran except Hanuman. Then Rama asked, why are you stopping? He told, you have not completed your speech. Then I said, you are the person you are going to find Sita. He gave that Anguti. Now we will find Anguti of Rama if you sit up to last. If you run like that, you will be missing some good tips from questionnaires. They may ask some valuable questions. You may be missing, which was not dealt by the speaker. You may be missing. So my request is, have patience. My promise, I am not giving Modi ki guarantee, Sambamurthy ki guarantee, that 10 minutes only my question and answers.
So, sir's question is, the substance, his registration is medium, but he has not upgraded himself.
Yes.
So, in that case, what?
Sir, I missed one thing. So, sorry for interrupting. So, in the current year, he is crossing that limit, in the current present 23-24. But last year, he may be small. So, whether we should see the last year limit or we should see the present limit, even if he is certificate.
See, now upgradation in Udayam portal, now they clarified that it is automatic. Once you are filing GST returns, from GST and ROC, they are taking the data and they are automatically upgrading him to the new category, number one. So you need to examine as on the date of payment. So as the date of triggering of the event, like bill booking, what is his status? His status based on the certificate given is still small. You can insist that this provision should be applied.
Okay, but when we checked it through internet, because I don't have the balance sheet of that supplier, so when we check the certificate, it is small.
Automatic. I'm telling, it is only a provision like it is a what you say bargain between the vendor and the supplier. They can amicably settle what to do in such case, as simple as that. Okay, right.
Sir, good morning, sir. Sir, good morning.
Yes.
Sir, good morning. Sir, so the bank people have reported to the income tax department under section 285 state under air category, that is 30 lakhs rupees. As well, the bank also reported it under CIB category also. So the assessing officer did not make any inquiry. So he has issued a show cause notice to the assessee to explain it is 50 lakhs and above. He got the threshold limits of 10 years. He has issued a show cause notice to the assessee, but assessee could not reply because he has not noticed. So the assessing officer has reopened it, under the belief that it is 50 lakhs and above. After receipt of this notice under section, deposited only 30 lakhs rupees as per my bank statement. This is my bank statement. But you have taken under AIR and under CAB, and you have taken this 10 years threshold limit. So your notice is null and void, he said. But assessing officer said you have not replied, onus is on you. He argued. This fellow argued that onus is also on you. According to 148, you have not made any inquiries. So then that is the fate of that notices, and who has to, how to close it, sir?
Senior persons, okay. Writ jurisdiction is always.
That is there.
As simple as that. See, assessing officer, he, honestly, for my experience, okay, it is my personal experience, they never believe your statement saying that they will count one data from AIS, another from CIB. Both they will count, they will say that 30 plus 30, 60 lakhs is crossed. So that's why my sincere urge, when your client gets notices, when he approaches you in the initial stages, give proper replies. So when you keep giving replies 3-4 times, finally under 148 he dropped the proceedings. In your case, you never replied. All of a sudden after 148, then you are saying that I want to press this concept.
Single officer has
Permutations, combinations possible later. The department counted 30 lakhs from AIS portal, 30 lakhs from CIB portal, because department is catching the data from multiple sources. So the assessing officer is saying total is 60 lakhs, not 30 lakhs. So the moment it is 50 lakhs or more, he wants to travel back for beyond 3 years. Since it is more than 3 years, it should be barred. Yes, a bank account. One bank account. That he means to say. The rejudicial would be the proper solution for that one, sir. So just I want to add one more thing, sir. This 50 lakhs, whether it has to be spent in 1 year or multiple years, if it is in asset form, the various years, first year you incurred in construction of a building for 26 lakh, next year 27 lakhs. So 26 plus 27 total is 53 lakhs. Then the assessing officer will for both the years, because he will count the 50 lakhs in aggregate, 50 lakhs in aggregate according to 149 subsection 1A. 50 lakhs limit is not year wise, it can be for number of years also. But in such case, he has to issue multiple notices. What is there? He will issue 2 notices simultaneously, just uploading in the portal only. Okay. So that point I missed to explain.
A small change suggested by the organizers, that the question and answer section will be postponed to the last after the indirect taxes session, so that already it is we are running late. It is already nearing 2 o'clock, so we will all break for lunch.
One small
and
question.
All questions after
Small question,
last.
sir.
So the small or big, because we will honor the organizers. Your questions will be taken after 4 o'clock. Thank you.
Thank you.
Both the speakers.
And I am from Busy Accounting Software. We welcome you to the world of Busy Accounting Software. Busy is as my colleague told, is an India Mart company, and it is there in the market for last 25 years. And apart from India, Busy is present in 20 countries. It is very simple to use, and it's packed with many powerful features, and that will help to make your accountant's life very easy. So what are the features? I'll just cover in a very fast way. As we said that Busy is easy to use. So why we say that no technical knowledge is required, no accounts knowledge is required for one to operate Busy. It's so simple that once we train them, they will be handle all the operations very easily through Busy. It is very flexible. It is affordable. Affordable in the sense we have 3 models different pertaining to the different industries requirement. We can suggest them which model is suitable to them, and it is flexible. Flexible means we say that Busy is packed with many powerful features. So because of that, Busy can be implemented in many business verticals, be it retail, trading, distribution, supermarket, manufacturing, or service industries. So Busy can implement everywhere because there are so many features packed in Busy. So it is very flexible. So hardly any add-ons required for the normal type of businesses. And it is, if any add-ons are required, we can do the customization also in Busy. So for accountants and CAs, lot of features are enabled in these Busys that will make their life very easy. So coming, as you know that for accountant and CAs, what is the most important in every business is GST nowadays. So in GST, you can create a party masters in GST. I'll just explain you how it can be done. Then you can search GST and HSN online through Busy itself. Date-wise GST and HSN rates. Nowadays we can see that the government very frequently changes the check return filing status of an party, how he is filing, whether it is quarterly, monthly, or is in a composition, that you can check. Error checking tools available in Busy, and monthly ITC tagging as per GST 2A 2B. I'll cover all these things in detail. So this is what I said, you can create an account of party, or we say account creation or the party account creation, when we have to create a masters in every software. So this is the screen from where we can create. So if I press F4 over here, I'll get this screen. I have to just enter the GST number of that client. If I enter the GST number and say validate, it will show me all the details over there. What's his firm name, what is his filing frequency, registered address and everything. And if I say there update and back, you can see there is an option there, update and back. If I say update and back, party masters, every fields will get filled up. So you don't have to type address or GST number or anything. Just type a GST number, validate, and then create account. So it's very easy to create an account in Busy. So now coming to the second part, as I said, very frequently the tax percentage gets changes in the middle of the financial year. So what we have to do, we have given an option over here that you can see from the down screen with effect from. So there I have to put the dates in, say for the example that 1st December 2023, government has changed a particular from 5% to 12%. So I'll mention the date that from 1st December 23, the next new rates will be 12%. So any invoices generated from 1st or 1st onwards will be on 12%, and all the invoices before December will be in 5%. You don't have to change or create new masters for that. GST 2B and 2A. This is really very important point as far as accountant and CAs are concerned. They are always, worry how to reconcile the data. 2A and 2B as you is nothing but the purchases what client does. All that purchases get uploaded into the system, and from the system we can directly download to the Busy. You can see all this. This is the live data. You can see that till February all the data have downloaded. This data we can download after 13th of every month. 11th is the cutoff date for filing GSTR1. And after 13th of every month, we can download this data in the BZ itself. Once we download here, we have an option. There you can see that I can do the reconciliation of the data, and I can even tag that ITC with my BZ data. So any difference in my BZ data and the data which are uploaded in the GST will get highlighted in the red, and you can take appropriate action, and you can tag those ITC which are uploaded, because it's a government rule that you have to claim ITC which is uploaded in the system and not otherwise. Otherwise people are getting notices for. So this is a very important feature as far as the client is concerned, and as far as accountant or CAs are concerned. This is one of the best features of BZ, where GSTR1 can be directly uploaded to the portal. There is no need to go to generate JSON or Excel, though we have given an option there, you can generate JSON, you can generate Excel, CSV file, but absolutely no need. With a little configuration in the BZ, you can directly upload with a click of a button all the data to portal. My experience shows with all my customers that GST1 filing takes hardly 5 minutes to file the returns. That's all the time they require, provided everything is in order. And we have given few checks. Before filing GSTR1, we have given few checks. You just go through the data on the screen, and you will see if there is any discrepancy, you will find the mistake what you have committed, that highlighted there. So you correct that and you file it. So once everything is correct, it takes hardly 5 minutes to file GSTR1. So it's so simple to file GSTR returns from BZ. One of the, again, most important thing of GST is generation of e-way bill and e-invoice. Right from the day one, BZ has given this provision that e-way bill and e-invoice we can generate from BZ itself. There is no need to go to portal. There is no need to do any Excel or JSON. You enter the invoice, you save the save button, and once you save, you will get the pop-up whether you want to generate e-way bill or e-invoice. Then you get the transport details where you fill up your transport details, and there is one more option available, that you can generate e-way bill in e-way bill, e-invoice inside only. So one report will carry both the things. E-invoice will carry e-report also. And the another best part is this: after generation of e-way bill and e-invoice, e-way bill number and IRN number and QR code, all these things will get printed on BZ invoice automatically. You can have a QR code of e-invoice, you can have IRN details on invoice, and you can have e-way bill number on the invoice itself. So you can print e-invoice, e-way bill as well as BZ invoice with all the corresponding details. And e-invoice, there are instances where people, just generate the invoices in a day, where the rush is very heavy. So they want to generate e-invoice after some time. So they can do the bulk generation of e-invoice with a click of a button. It will show all the summary, what are the invoices you have generated e-invoice or not, and then you can take appropriate action and you can generate e-invoice at a click of a button. So as I said, the single step. Another part we are covering is about TCS and TDS. So something like, TDS may we have a 194Q and the reports form of 26, 27, everything we can integrate in BZ. So while doing the configuration, we get this screen for the TDS. So there we can mention 194, what do you want? And apart from that, the limit which is exceeding about 50 lakhs, it will automatically determine that limit. If you enable this feature, enable that feature in Party Master, it will automatically enable that feature and enable pop-up. Whenever you cross the 50 lakhs, you don't have to remember. Whenever you cross that limit, and automatically the pop-up will come that you have crossed up the limit, and now you need to generate, you have to cut the TDS and TCS on that particular account. So everything you can just predefine, and you don't have to remember. So your life becomes, get all the reports like 26Q, 26Q, annexure, 27, everything, all the reports. And you can have a e-filing of this, provided you get a text file in TDS. They have not really integrated like GST, but they generate a text file. That text file with this software, you can upload I am sure you can save lot of GST time in calculation and everything. Otherwise you are spending if they are not proper software use or they are generating using Excel or manually. You can create bulk vouchers. Audit trial report is also there as per the MCA guidelines. Then clause 44 that which was introduced last year, we have covered that also. You will get the tax audit report accordingly. Export reports, you can export reports in Excel, Google Sheet or PDF. Concerned to an accountant and CA. But apart from these features, BUSY is have a lot of features. Because of the time constraint, I cannot, which is useful for the mobile or electronics where they can track. So they have a unique number for each product, so they can do the tracking of that with serial number option. We have a barcode option. This is again a very good option in BUSY where client can design his own barcode, he can generate his own barcode for the product. If the many products nowadays comes with the barcode, but the few products which doesn't come with a barcode, they can generate their own barcode and they can manage their inventory well. Then we have a parameter. This is one of the best features of BUSY. Parameter is nothing but the managing inventory at micro level. If I take the example of garments, you know, they deal with shirts, t-shirts, ready-made garments, वगैरह. So what they want to have a inventory to be controlled at micro level, means at size and color wise. So 32 size green color, 32 size red color, how many stock they have, size and color wise. So parameter feature will help them to maintain that, and at that level also we can generate barcode. So their life really becomes easy. They can, while doing the invoice, they have to just scan the barcode. Once they scan the barcode, automatically all the details will be captured and they can manage the inventory very efficient way. Then we have a MRP by stock where FMCG prices changes very frequently. Production option for the manufacturing, we have bill of material option there, so they can control the production option also. Email, WhatsApp and SMS, you can do it from the BUSY itself. Project wise, they can maintain the cost. If the builders, if I take, they are running 4-5 sites. So project wise, they can maintain the cost centers. So they will come to know what is in and out in that particular project. We have multi-currency option also, and it is suitable for import-export business again. We have option of head office and branch office. We can sync the data from head office to branch office either in online or offline mode. We have BUSY on mobile also, where we can generate lot of 100+ reports. We can generate sales, invoice, quotation, everything from mobile. One more option is BUSY on online, where you do not have to buy the software, but you can use our online platform and run the BUSY on the cloud. Reconciliation of e-commerce. We have recently integrated our software with Amazon, Flipkart and Shopify. So all these data will get implemented, saved in BUSY very easily with this option. Now our support is 24/7, 365 days. And I am Deepak from S Systems, and this is my number. And thank you for your time and attention. Thank you very much.
Sir, thank you so much for your time. I just have a small request. We have a stall outside, BUSY stall. For people who register, we have goodies for you, so you can collect it from our stall. Thank you so much. Just register and collect the goodies. And also, we have a 50% discount today running. So people who register and interested, please contact us. We are just sitting in the stall. Thank you so much.
Good afternoon, everybody. Now we can start our second session, which will be chaired by our today's session chairman, Sri M. Srinivas Garu, retired Principal Chief Commissioner of GST for Tamil Nadu and Pondicherry. Sir, you are welcome, sir. Srinivas Garu. Panikumar Garu, please hand over a plan to sir. Now I request Mr. C.A. Sudhir Garu. Vibrant Sudhir Garu, మామూలు నిద్రపోకుండా చూడాలి ఇప్పుడు మీరుగా on GST session. Sir, I request Vijayan Garu, please hand over a flower bouquet, sir. Those people who want to go to Yadadri, at 4 o'clock the bus will start. You please be ready and be in contact with Sir D. Srinivas Prasad, who is organizing that Yadadri tour. Thank you. Now I request Mr. You can commence your session, sir. Sir, before commencing, sir, I request Mr. Srinivas, you can brief the profile of Mr. M. Srinivas, sir, retired Principal Chief Commissioner.
Good evening, everybody. I'm just introducing Srinivas, sir. Srinivas Mandalika, Indian Revenue Services, Indirect Taxes and Customs, 1988 batch. Principal of Chief Commissioner of Central GST, Tamil Nadu and Pondicherry. And his education qualifications is MSc, Marine Sciences with Andhra University and Vishakhapatnam. He had his LLB from Osmania University and earlier served as Kerala, Karnataka, Tamil Nadu, Gujarat, Maharashtra and Telangana for 9 years at Hyderabad. And he is a Chief Customs Commissioner, Bangalore, and Principal CGST, Tamil Nadu and Pondicherry. And convener of Media and Entertainment Sector, GST Council, and member of the Committee for Valuation of Goods Manufactured on Job Work. And is a member of Committee for Review of the Goods Charged to Duty on MRP or RSP. And co-opted member of the Executive Body of ICSI, Hyderabad chapter during 2017 and 2018, and implemented faceless assessments in customs from pilot stage. Thank you very much.
Thank you, Srinivas. And next I request Nagaraju from Bongir. He will brief the profile of CA V. Sudhir Garu. Yes.
Good afternoon. It gives me an immense pleasure to welcome Mr. Sudhir V.S., BCom LLB, FCA. Aged 40 years, is a lead partner at HNA and Company, having their offices at 14 locations, which provides consultancy, audit, and litigation services. Schooling and graduation in Bangalore, qualified as a chartered accountant in November 2006. Sorry, sir. He is an associate member of Institute of Chartered Accountants of India, Institute of Cost Accountants of India, and Trade General Services, Tax Review and Manupatra. He is the master trainer for the Institute of Chartered Accountants of India, New Delhi, and a faculty in National Academy of Customs, Excise and Narcotics, which trains the departmental officers. The freedom of Telangana. Okay, sir. సార్ గురించి చెప్పాలంటే చాలా ఉంది సార్, చాలా ఉంది. ఓకే, చాలా ఉంది అది. సారీ అన్న, సారీ. నేను చదువుతానన్నా, చదవమంటే చదువుతా అన్న. ఇక్కడ వరకు చదువునా
సరిపోతుంది సార్,
చాలా
అందరూ
Sir, I will continue, sir, no problem. Okay, thank you, sir. Thank you very much. Now I request you to Sudhir Garu to take up his session on the analysis of input tax credit under section 16.2 and 16.4 and recent landmark decisions under the GST. Sir, please take over.
I request the chairman, sir, to speak on this occasion.
Good afternoon. The second session is the most difficult session because after lunch we are all used to have a small nap. I can see some of the people. Of course, prior to reaching the dais, even I was dozing a bit. But still, we'll make our best effort to make you alert, raise queries. Mr. Sudhir has prepared a wonderful presentation. I had a quick glance of it. Let me put it this way to set the tone that the issues related to ITC contribute to about 60% of the litigation in GST. That is our humble estimate. The reasons are multifold. It is nothing new, but still it is much restricted and controlled by certain rigid procedural features in GST. If you see 16.1, the parent provision of ITC, it says subject to the procedures and conditions. That is, the first phrase itself says ITC is available subject to compliance to the procedures and the conditions laid down in the statute. ITC, the provisions, is a beneficial scheme and beneficial piece of legislation, provided it is not the right. Even the courts have held that ITC is a beneficial scheme. It's not a right. And it is available and admissible subject to certain conditions. In what circumstances it is available, for what purposes it is not available, all these are clearly mentioned. That may not stand. But of late, courts have come up with certain very important observations where it says that if the recipient has not committed any mistake and if he has complied all the provisions of the law and the fault lies with the supplier, you should not initiate action against the recipient who is a beneficiary without actually initiating the action against the supplier who failed in compliance, who failed to pay, who failed to file the returns, who failed to actually report in the GSTR1, etc. So let us first go through the provisions and then we will interact. Thank you.
Thank you, sir, for setting that tone. Good afternoon, all. Okay, I thought much less for voice, it's better, but it could be much better. Good afternoon, all. Great. So, always, I don't know why, I've been always given a post-lunch session. So, I think organizers want to ensure that I'll eat less, so that I'll not... Okay, thank you. So, anyway, so the topic which is also is very interesting. I think if I look at in the history, the most disputed was levy in central excise or VAT or something. Levy with classification, that is the rate of tax. But because of the wide definition of goods or the service, as the case may be under GST and supply, which is very wide, the disputes of levy and also to the extent of classification is minimum. So various disputes which comes here is most of a input tax credit. That is very keen. What is eligible, what is not eligible, and various interpretation to the best extent possible of the field officers. You will get a notices. So you don't know whether that has to be relayed or we have to rely on the book or the few experts. So what has to be done, not very sure. So thereby this is an interesting topic which has been given. So the topic which has been given to me is just to give you an overview of input tax credit. and more specifically stress on two sections under input tax credit, which is 16.2 and 16.4, which is condition for availing the credit and the time limit for availing the credit. So these are the two things which I'll be going in depth, but otherwise I'll give you an overall scheme of how the ITC is going to be there. After that, there are certain important recent landmark decisions is what supposed to have been covered by me. So I have compiled a lot of decisions. So you have to tell me when should I stop, the organizer. It is like this, one of the seminar I asked when to stop. They told, sir, you are big speaker, you have come all the way from Hyderabad. How can we give you time? After 5 o'clock, we are not there. You can keep on speaking. Yeah? So give me an upper limit so that you will also be there. 4:30. Okay. So good. We have sufficient time. Srinivas sir also, it's my fortune to have Srinivas sir as a chairman today. And his experience, rich experience, I have appeared with before him several times. So I know the level of knowledge he has and the level of preparation he does for even in the adjudicating the case. So he has come here also prepared. I was seeing his notes. So he will also be spending about 15-20 minutes adding to or correcting what I have told and also what thought process he wants to give. So what I'll do is I'll take about 40-45 minutes and cover whatever the case which has been there, then over to Mr. Srinivas. Then we can also take some questions if time permits, right? So with this, let us get into the analysis of the input tax credit. If you look at the scheme or structure of the input tax credit, these are the sections from 16 to 21, about 6 sections which is governing the input tax credit. So one fundamental is that anything which has been there, it has to be there from a act. It cannot come directly in a rules or a notification. It should be part of the act. The act has to empower to make a rule, the act has to empower to give a notification. So thereby looking at the act is very, very important. Section 16 gives the eligibility and conditions for taking the input tax credit, very important. As Srinivas sir was also telling, this is the parent section. You see how it starts with, so you have to go, everything bounds to section 16. So 17 you have the way of apportion when you have a taxable and exempted supply, and also deals a very important section of section 17.5, which is not a topic of today, which is a blocked credit or a restricted credit. So that is covered under section 17. 18 gives in special circumstances in case of sale or transfer of business and things like that. 19 deals with your capital goods and the inputs which has been sent for the job work. 20 and 21 is more about your input tax input service distributor scheme. So 1st of April onwards, it is supposed to be mandatory that the input service distributor is there. Till now, whether you could have done it through a cross charge or ISD, both were permissible. 1st of April onwards, of course, it has to be notified that it has to become a mandatory. So this is the broad way, the structure of the section is. So let me get into section 16.1, which is the primary section 16.1 and 16.2. So where it says the every registered person shall be entitled to take input tax credit charged on any supply. So here you have to look at few important things which I have bolded, that who can take the input tax credit is only a registered person. Earlier in service tax or in the SENVAT credit rules, any person reference was there. So even if he has not registered, he was entitled for input tax credit. In this case, you only a registered person can take a input tax credit. So thereby there is a small challenge which is coming when the, this physical verification which has happened, there was a special drive and government wanted to remove all those fraudulent or bogus dealers. So in that case, there were some genuine dealers also caused an hardship because at that time when they came, they were traveling or things like that and they were not able to found, and they declared them as bogus. So there is a registration which has been cancelled from a retrospective effect. So if a registration is cancelled from a retrospective effect, he no more be a registered person for all these years where he has already done the business and filed the returns. So the department is also looking at denying the input tax credit also because the fact that you have not been registered. See, of course, if I am paying the output tax, the input tax credit should be given and the registration has been done retrospective. So very important that you need to get this squashed, revoke the proposal for the retrospective suspension and the dismissal, and you have to get this revoked. Otherwise, a challenge of input tax credit also will be there. Very important is there are few people who will call and ask you, sir, when should I take a registration? You say, sir, 20 lakhs, sir. Till 20 lakhs, you need not worry. So then you say, so 40 lakhs, no, for Telangana 20 lakhs, nothing to worry. Up to 20 lakhs, you don't take a registration. They also don't take a registration. They start purchasing the goods, capital goods and everything, on which the input tax credit has been there. What will happen to that? Can I go back and claim? That will be a challenge. So thereby you have to ensure you have proper registration before you procure the big ticket item where you want to take an input tax credit. So when the client is asking when I have to take a registration, it is not an easy question. Right? In fact, registration is the biggest professional service which you can give. Although you see that back of an auto rickshaw, I see some people are giving GST registration only 500 rupees, 1000 rupees they'll write. GST registration itself is the biggest professional service because it will be involving you to how to structure his business, whether he want to go for composition, whether he has to go for input tax credit, whether he should claim the basic exemption or not, what should be the classification, what is the invoice records he has to maintain, registers he has to maintain, returns he has to file. All these things is a guiding document and an advisory which you have to give. This cannot happen for 500 or 1000 rupees. Right? So the moment you go there 500 or 1000, it will be costing more than few lakhs, less than our professional fees for these people who will opt for them. So thereby it is very important at that pace that if you want to take an input tax credit, that guy should be registered. Then what I can take a credit, I cannot take credit on anything. It is a tax which is charged on the supply of goods or services. So it has to be charged in the sense an invoice has to be issued, the GST has to be charged, and that only I'll be able to take a credit, and it has to be charged to him. That is, the invoice should be in my name. In central excise, the concept was totally different. In central excise, the goods was duty paid goods, and anybody could have taken the credit. Even a job worker could have taken the credit as long as it is coming under a duty paid challan. Because the duty moved along with the goods as far as the GST is concerned. Here, the duty is moving from a person to person along with the goods, charged on the goods, charged on him. So only the recipient which has been there, that the invoice should be in your name, then only you will be eligible to take the credit. And this has to be what will be there? This has to be used or intended to be used in the course or furtherance of business or commerce. Two things. One is, it can be used in the normal business, or it could be an expenditure relating to a new business which you are starting. May or may not expenditure, you will be eligible to take the credit. And very important, it says, in the course or furtherance of the business. This is actually giving you a course subject to section 17.5 and all other conditions which has been given. I don't know if you people who have already heard me, I always take this example because it's very important for us to understand how wide this is. You know this company called as Hindustan Coca-Cola? Yeah? You know what they manufacture? Soft drinks. Yeah? That soft beverages. So that is what they believe as they manufacture. Actually they manufacture concentrate for it. Right? This concentrate has been sold to their franchisees, bottling units, which has been called as who manufacture the soft drinks which has been shown in the advertisement. So this Hindustan Coca-Cola was subjected to audit. The audit department got an invoice of Katrina Kaif, some X amount being charged. They told, I will not give you the credit. Then they asked, why, what happened? If it is Katrina invoice, you will not give, is it? No, I am not bothered about Katrina or Zahir Khan. I am looking at what is the product Katrina shows in the TV. Soft drink? What is your product? Concentrate. How can you get a credit which is not your product at all? Valid? So, Hindustan Coca-Cola argued, sir, please see input service definition under this NVAT credit rules. One is that it should be used in or in relation to course of the manufacturer. And it also includes expenses relating to business such as so and so, so and so, so and so. That means it's only an indicative. So any related to expenditure of the business, I'm eligible to get the credit. I don't have a end customer for concentrate. As per my business model, I'll only tell to a franchisee. If I give an advertisement to promote the business of my franchisee, my business is going to increase. Thereby, this is an expenditure in relation to business, furtherance of the business. Thereby, I'm eligible to take the credit. Mumbai High Court told right argument, go ahead and take the credit. So what happened next? There was a budget which came in, they deleted the word such as and made it only restrictive. Now, when 2017 the GST was there, they have again given this wide definition of any business related expenditure, you will be eligible to take the credit, of course subject to section 17.5. 17.5 overrides this. It may be a business. When I tell this, a lot of people will, sir, car is there, na sir? Car is 24 hours for my business only. I'll send for my guest, pick up and drop off the guest. I don't know anything. My personal use also, I'll not use it, sir. I am having Merc. Why should I use this Tata Indica? I will not use it. For personal use also. Why I should not take the credit? It's business expenditure. Sorry, sir. Because it is given under 17.5, you will not be able to get the credit. I don't know how many of you are from Karnataka here. In Kannada, we have one thing which says, if even God gives the gift, it seems, but the pujari will stop. Right? So 16.1 gives everything. 17.5 is stopping you. Not able to get the credit. Right? So that is what you have to keep in mind. Otherwise, all business related expenditure, you are eligible to take the credit. Especially those who are in manufacturing, they have been seasoned under central excise. Even yesterday we did one audit of a large manufacturing company. Even there today they are not taking any input tax credit other than their manufacturing. They have not taken credit of AC installed in the corporate office. Because earlier everything should be AC installed in the manufacturing facility only, they were giving input tax credit. They are following the same psychology. We identified for 1 year the eligible credit which is not covered under 17.5, 1 crore of credit they have lost for 1 year. So imagine for last 6 years they have lost 6 crore rupees on this sort of an eligible credit. Your staff welfare expenditure eligible for credit. Your colonies, staff colonies, because you are working in a remote area, people will not join your organization if you are not giving them the employee quarters. So thereby you do an employee quarters, maintain it, do lot of recreational activities, all those things, business expenditure allowed under income tax, you are eligible for taking input tax credit. Right? So it is very, very wide to take credit of everything. The said amount shall be credited to electronic credit ledger. So this is also very important. Earlier under central excise, taking the credit was in my RG23 registers. My private register, I was taking the credit. If I missed to do it in the excise returns or the service tax returns, still I could have taken a credit because the credit was supposed to be taken in my private record. GST, sorry sir, you don't have a record, I don't have a record, let's have a digital record. Anything come in electronic credit ledger, then only you are eligible for credit. So a lot of people, what has happened is they have not filed the returns, right? You are eligible, it is showing in your GSTR 2A, but because you did not file the return, taken it within the time limit under the GST and you have taken it under 3B, that will not be eligible because 16.1 itself it says it has to be taken to the electronic credit ledger. However, I am surprised to see one High Court judgment. So sometimes judiciaries are totally judicial. I think they'll go one-sided, blinded also sometime maybe, not looking at the provision. So Madras High Court told, in one of the decision they told, no, you can take the credit in GSTR 9 also. And they remanded the matter for verification of the invoices. Of course, what the facts was there is that the liability and credit both were disclosed in GSTR 9. That was some change in the fact which was been there, but that Madras High Court decision is there.
So can we focus on 16.2 and 16.4 and then come to the judgments and then other issues? I think we are spending too much on 16.1.
Yeah.
And
So,
I request you to refer to the conditions and restrictions phrase.
Yes, sir. So then it is subject to such conditions and restriction as may be prescribed in the manner specified under section 49. So the condition is that utilization and all those things is there. So that is what is coming as far as the condition is concerned. Then comes is section 16.2, which is the conditions for taking the input tax credit. So one of the condition is that he should be in possession of the tax invoice, right? So tax invoice, possession of tax invoice, original tax invoice is mandatory for you to take the credit. Although it is part of your GSTR 2A, 2B, and you have a e-invoicing or whatever it is, the possession of tax invoice is one of the condition. It is not only the tax invoice or any other document as may be prescribed. So the rules prescribed, these are the documents on which you will be able to take the credit. One is invoice under section 31 which has been issued. Self-invoice issued under 13(1)(3)(f). So what is this self-invoice? You know that there is 9394. 2 sections which is there under RCM where I have to pay reverse charge. In that also, I am dealing with an advocate who is not registered at all. In which case, law mandates me to issue a self-invoice, and that is a document on which I will be eligible to take the credit. However, the condition is I should have paid the tax. I cannot just create a self-invoice and take the credit. I have to pay the tax and do it. Now there is one more GTA who is registered under GST, is giving the GST number. Maybe for warehousing or some other reason he is registered. But he is saying that you pay GST under reverse charge mechanism. So this person is registered. I need not give an invoice under 31(3)(f). So in this case, this invoice followed by my payment method will be eligible for taking the credit. Then debit note, section 34 gives a scenario where you can give a debit note, that is wherever there is a short payment of tax, there you can give a credit note and you will be eligible for taking the credit. A bill of entry. So for IGST, on imports we know that there is an IGST payment which has been there. For taking the credit of that, the bill of entry is a valid document without which you will not be eligible to take the input tax credit. And last is your input service distributor challan or invoice which has been given. Only these are the documents you will be eligible to take the credit. You cannot take a credit on payment voucher. You cannot take a credit on DRC 03. So these are all the only documents on which you will be eligible to take the input tax credit. Then the further condition is says the details of such invoice or debit note as mentioned above shall be furnished by the supplier in the statement of outward supply. That means my supplier should have filed GSTR 1 and that should be communicated in my GSTR 2B. It should be in my GSTR 2B. Then only I will be eligible to taking the credit. So this is with effective from 1st of January 2022. So it is very important for us to understand that we have tons of notices. GSTR 3B not matching with GSTR 2A. Your whatever serial number of GSTR 9, H or something, whatever that GSTR 9, you have taken more credit than what is there in your 2A. All those things will be relevant only prior to January 2022. First time in January 2022, they come with a condition that it should be part of year 2B. Till then, there was no condition. So thereby, if you have all other condition met, that is a valid document, receipt of goods, all other condition, you would be still eligible to take the credit prior to 2022. Even if it is not forming part of your GSTR 2A or 2B as the case may be. So next is very important is he should have received the goods or services. So receipt of goods is very, very important. It is important for a month-end transaction. Many cases what happened, the goods gets dispatched on say 30th of March from Delhi. To reach Hyderabad, it will come on 2nd of April. So invoice is generated by the vendor on 30th, obviously, because without generating invoice, e-invoice or a e-way bill, he will not be able to ship the material. It will be showing in my GSTR 2B for the month of March. Can I take the input tax credit? No. You will be eligible to take the credit only in the month of April because the goods has been physically received in the month of April. So it is also important that you also have to maintain a proof for receipt of the goods. So what is the general proof? You have every manufacturing facility will be having an inward register. So if it has been maintained properly, chronologically, even if it is yourself also, it has been maintained on a day-to-day basis, that will be taken into consideration. Many cases the traders may not be having a record. So anywhere there is a challenge of challenging the receipt of the goods, there may be having certain challenges in terms of proving it. So having a proper register is required. Second, how will you prove receipt of service? Goods at least is tangible. You can show it with e-way bill. You can show with payment slips that it has come to my factory. How will you show services? So that is again a big challenge which has been there. Earlier when the export of service rules and the service tax was there, they also had this delivered outside India, received outside India. Finally, NASSCOM advised that service cannot be proved of receipt or delivery. So do away with this condition. They done away with that condition, but the still condition is carrying on here. We have to see how things will go there. And there is also a deemed receipt when you are doing a bill to ship to. There is a deemed receipt. I am not getting into it. The details of input tax credit in respect of the said supply should be communicated to registered person, that it should be part of my 3B, and it should not be a inadmissible input tax credit because of the person who is there not filing the returns, my vendor not filing the returns, or he is taking more credit what is eligible. So all these conditions should not have been violated by my vendor. That is something which is there. Next comes the 16(2)(c). It is subject to section 41. The tax charge in respect of such LV has been actually paid to the government either in cash or through utilization of input tax credit admissible in respect of said supply. So it is very important that we have to ensure as a recipient that the tax has been paid to the credit of the government. Now, how will I prove this? How will I prove the tax has been paid to the government? You can prove only to the extent what is possible for you. You can check GSTR 2B that he has declared in GSTR 1. You can also check GSTR 3B whether he is filed or not. The portal also gives something as a percentage of liability discharged. That means in 1 if I have shown 100% of 100 rupees as a liability, in 3B how much I have paid? 100, 98, 101, what I have paid, that will give you a percentage of register. As on that date, it gives. This is only what is possible for me. Now, I cannot go to the personal records of all my 1000 vendors or 1 lakh vendor to check whether he has paid the GST or not. What records available, only that is required. Any condition which is impossible to fulfill need not be fulfilled. But you have to make a reasonable efforts to tell what you will be able to give. So if you are storing these screenshots, this acknowledgement for you, that will be more than sufficient. Proving payment is one. Second is proving that the tax has been paid by the admissible credit. Now, where will I go? Where will I get his input tax credit statement to check whether all these credit were admissible or inadmissible? What is 17.5 item? What is not related to business? What is relating to personal use? Where I can do an audit of all my 1 lakh vendors or 1000 vendors who are there. So this is not something which is practically possible. So this is something is there. This section 16(2)(c) has been challenged in Telangana High Court and the stay also has been granted subject to paying pre-deposit wherever there was a demand. So that is also something which has been happened. And even in case of Suncraft Energy, the Kolkata High Court which is later went into the Supreme Court, they also are making it very clear that if it is there as per your part 2A, the payment whatever is there, you will not be able to force the recipient. It should be something to do with the supplier is what you have to take it. And the last condition here for taking the credit is he has to be filing the returns. So the taxpayer has to file returns under 39, that is the 3B has to be filed, then only he will be eligible for taking the input tax credit. Right. So few case laws on section 16(2), I talked about Suncraft. So this is another Kerala High Court decision which says that the prescription of condition could not be considered discriminatory to the contravention of Article 14 of the Constitution. Impugned provision 16(2)(c), 36(4) do not satisfy the test of manifested arbitrariness. Therefore, challenge to the constitutional validity of impugned provision must fail. So they told that 16(2)(c), whatever is there, it is valid. You cannot challenge that. Telangana High Court, still there is something which has been there. And this is also a Guwahati and Kolkata High Court also writ petitions are pending on 16(2)(c). Kerala has disposed saying the 16(2)(c) is within the wires of the law. Next comes is 16(4). 16(4) is time limit for taking the input tax credit. So now the important question comes is whether the input tax credit is a right or it is a deduction subject to condition. So this has been made very clear. Even in the Supreme Court, it has been held that it is not a right. It is a deduction subject to the condition, and you are bound to do all the conditions and the time limits prescribed by the Act. Originally, under Sunvat credit rules of 2004, there was a decision of there was a scenario where time limit was not prescribed. Upper time limit was not prescribed. People were taking credit beyond 5 years also. Later, they imposed a condition of 6 months, which was challenged. They told the government has sufficient powers to have a time limit being fixed. So 16(4) challenging whether the time limit is there or not is again something which has to be judicially settled. There are still certain cases where it has been pending, but AP High Court in Tirumala Konda playwood, they told that 16(4) is valid. So we have Advocate Naresh with us who argued this case. So any doubt on 16(4), is the person available in the high tea break? You can barge and ask all your question to him. Yeah, Narendra, sorry, right? Narendra is here. Right? So this is the AP High Court judgment where they upheld 16(4). I'm not getting into in detail because of want of time. So these were the provisions of section 16(1) and 16(4). Mostly I've touched on the condition. And 16(4), which is a time limit, which is bothering many of the people. When I was sitting here, I think Mr. Rosi Reddy or somebody was also making a mention, saying that, okay, 16(4) has a time limit, but initially there was a lot of confusion in the law. So why should the government should not consider giving some amnesty for initial years of the law? This is also something from the Federation. We have also made various representation. So we have to see how it goes, but there are a lot of people who have taken the credit beyond the prescribed period. So that is something we have to see how it goes in the judiciary. So as of now, there is no much of favorable decision, I can say, except for few petitions which has been pending. Then comes is few decisions, other important decisions, which I'll quickly take through and wrap it up. So this is a decision where amount is paid during the investigation. They told any amount which has been paid, without that being a self-assessed, the government cannot use the money. Okay? Only when you make a self-assessment, that is you declare that in GSTR 1 and 3B, then it is a self-assessed, government can take that money and use that money. Any money other than your self-assessment, even a single rupee has to be taken, there has to be a proper principle of natural justice followed, a notice should be given, order has to be passed, then it has to be appropriated. So this is a case where the amount was paid during the investigation. So you know how the investigation is happening nowadays. Earlier it was not like this. Earlier they were saying, sir, I advise you to pay, you don't have a case to context. Why unnecessary you are listening to your consultant, you are going to lose, you will pay unnecessary huge amount of interest and penalty. No sir, still I want to contest. Okay sir, me karamam, I will give you a notice. That is how it used to be earlier. Today, getting notice, if somebody is successfully able to get the notice without paying, is the best consultant in the city. Right? They don't want to give notice only, they only want to pressurize, dumpify and take the money. That is what we are seeing in most of the cases which has been happening. So now this is a case where they told I have paid under stress and pressure. Whether that amount can be assessed as a self-assessed, there is a no. You can go for a refund of it. So that is what is being told. Even in the Vinod Metal it says, voluntary deposit made under 1735 during the adjudication cannot be excluded from considering it as a part of the pre-deposit. So this is a different case where they say that I have made this amount under section 73(5). I am contesting, I am not accepting the liability. Whether the amount is already paid during the investigation can be considered as a pre-deposit, answer is yes. Because this is also again a grey area where they are saying, no, the net amount what is outstanding. So 1 lakh is the demand, I have already paid 50,000. Okay, pre-deposit how much I have to pay? 10,000, 10%, right? 10,000. So already I have paid 50,000, so I should be able to prefer an appeal without making any payment. But department is insisting to pay 5,000. That is 1 lakh minus 50,000 already paid, balance 50,000, on that you have to pay 10% and another 20%. So this case law says nothing doing, what you have paid under 73(5) can be taken as a part of the pre-deposit. So that will be useful. And this PPT also will be circulated to you. There are a lot of text here, don't worry much about it. So I think we have the email IDs of the participant, or otherwise also all the 3 associations, it will be sent it for circulation, don't worry about it. Next you have, this is a case where they told, okay, I have paid X amount, 50,000 rupees, 5,000 was the pre-deposit, 45,000 they claimed a refund. Court told yes, 45,000 has to be given as a refund. Because it was paid during the investigation, it is not a self-assessment, you have to give a refund of 45. These are all very important cases because huge amounts are paid during investigation. Pre-deposit is only 10, another 20-30%, but mostly 80-90% of the amount has been paid as a pre-deposit. Sometimes lakhs, crores are stuck. You can use this case laws and apply for a refund. Audit after closure of the business. So this is one of the cases where they told, I closed my business, I surrendered my GST registration, thereafter audit cannot be done. Audit has to be done when my registration was live. So when I apply for the registration, you can do the audit, then close my registration. You cannot close it now, come after 1 year and do the audit. So that is this Madras High Court decision which is coming. This is a case of reissuance of show cause notice, where what happened, state authority gave a notice, or center authority, I don't know who gave. One of the authorities gave a notice for same issue, 2A versus 3B, adjudicated the matter, closed. Again another authority is giving the same notice. So this is not permissible on the same issue, second show cause notice cannot be given. Non-considering the, this is not the period, this is not considering the directions of the OIA. So here it was a refund case. They went for, there was no BRCs. They took a bank certificate instead of BRC. Bank certified that these invoices are realized. They went to Commissioner Appeals. Commissioner Appeals told, whether BRC or otherwise, both banker only is giving. Banker told is received. What else you want? Consider this and give the relief. The order rejecting the refund was set aside. So there was a new refund application again which was asked him to make for asking for a refund because the amount was already credited back. They made again a refund application. Again the officer told, no EBRC, I am going to reject the refund. So they told already it has been settled by the Commissioner Appeals. Although it is for a different number or whatever the appeal number, you have to use the same and give the refund. So that is what is there. PR hardwares, very important. He says minimum 3 months has to be given before passing the OIO. Show cause notice has to be issued before 3 months plus 3 opportunity of PH. In this case, they had completed in 2 months and thereby this was been quashed. So 3 months should be a minimum gap between SCN and OIO. In between, there should be a 3 opportunity of being heard. So it cannot be given at the last moment. Detailed order. So this is a case where a detailed order and the signed copy of the order was not been given. The order was not signed. Only the summary was given. Recovery was done on a summary. They went to an high court. They told you cannot do a recovery when the order is only on a summary order. The detailed order should be there, which is a speaking order, which is an appealable order. Then only you can go for a recovery proceedings. So this is also something which has been there. There is also a recent decision of Telangana High Court where they have upheld that the order which has been issued, the unsigned order which has been issued, cannot be called as an order at all, and thereby that has to be squashed. Now what happens? Another order whether it can be given for 17-18 because 73 it's already time barred. Nothing can be done for that period. They cannot give 74 notice for the same allegation because till yesterday I was innocent, non-fraud. Only because that notice become time, but today I cannot become fraud. Correct? Now, if I were a fraud, I should have been fraud from the day one. So that is also something which you could look at doing it. ASMT is mandatory before issuing DRC 01. I think there was also another Guwahati High Court decision also which was been given. But AP High Court says it's not essential. There is a Guwahati High Court and I think then only you can propose to ask tax from the recipient. So that is what this particular decision is. Very important for you to look at. Interest on refund. I make a refund application. I get a show cause notice followed by the order, appeal, first appeal, second appeal, then finally I get a refund. From when I am eligible for the refund? I am eligible for the refund from the 60th day of my making the application. All these things are not counted. I should be eligible for the refund. If I am not eligible, now if the refund is rejected, anyway, no refund, no interest. Interest on refund, sorry. Interest on refund should be given from the 68th day, right? Next comes is, this is the bank guarantee was been given. When the e-way bills and all, you can give a bank guarantee and get the goods released. So if the bank guarantee is not been released, you will be eligible for 6% interest. Here the department told there is no provision. Courts told nothing doing. If you are holding the bank guarantee, it's the money you are holding of the taxpayer, you have to pay 6% interest. And Tonbo imaging is again a Madras High Court decision, Karnataka High Court decision, where this was, this 1.5 limit condition was been given. So when I'm in export, I'm claiming a refund. They told my export price should not be more than 1.5 of my domestic pricing. That was a condition which was being prescribed. They told this condition is unwarranted and this condition was done away with. This has been quashed. Composite supply, this is an advance ruling of Telangana which has been there, where they were doing some work for the Singaneri Collieries. They were doing the supply and they were also doing some services along with that. Independent contract was being given. So they told this contract has to be seen independently, not together, because the total clauses are totally independent of each other being supplied. So this is again a very important decision for you to structure your contracts, which is very independently. A different treatment for that and the rate can be adopted based on this decision. Late filing of GSTR 9. Most of you are aware there was an amnesty which was given in 2023, April or August, I think. 1st of April to 31st of August 2023, they had given a amnesty scheme. Now, I am a person, prior to 31st of April, 30th April, the scheme was given 1st of April. With delayed, I have filed my GSTR 9. Department told you are not eligible for amnesty. You should have further delayed till I gave my scheme. The person who is delayed for 600 days is eligible for refund. Person who is delayed for 100 days is not eligible for waiver. Not refund, waiver of the amnesty. Court told nothing doing. Anybody who has filed the returns delayedly up to 31st of August 2023 should be eligible for this amnesty scheme. That is what this decision is there of the Kerala High Court. Amendment in GSTR 1. We all know there is a time limit for amending the GSTR 1. In both this scenario, they told first one they told it's a revenue neutral, and second one they also told that there is a genuine problem which has happened. Based on this, the recipient is having a problem. So thereby, beyond the time limit also, allow him to amend the registration. Of course, this was not made as a law. It was given as a specific relief for this assessee. So if there is any difficulty in GSTR 1 which you require, you can always go for a judicial route and say whether you will be able to take it. So this is Shanmugam hardware. I already covered this. In GSTR 9 also it says you will be eligible to take the input tax credit. And this is on intermediary services. So where they were rendering services to the foreign party for making investment. So it was only a one-to-one advisory. They told this is nothing to do with the intermediary at all. Intermediary is more of commissioning or brokeraging, which is not there in this case. Then comes a famous decision of Prahita Construction, Telangana High Court on joint development agreements, They told the transfer of development right pursuant to joint development agreement is not equal to sale of land, and thereby it is subjected to GST. So that is the decision of the Telangana High Court. So I have quickly taken you through various decisions. This has been available for sharing. So this completes my presentation. Thank you all for patience listening. I am again here to take any questions if it is there. Thank you. Over to Srinivas sir for his comments.
Thank you, Sudhir, for a very, very elaborate and wonderful presentation. You left very little things to be covered by me, but yet I thought I'll add a few aspects which are not covered. To avoid duplication, I will limit myself to the issues which he has not covered. Number one, I'm sure many of you are aware that the adjudication process has been completed for the period 2017-18 recently, and for the year 2018-19, the last date for issuing show cause notice was 31st of December, and adjudication last date is 31st of March, but now it is extended to 30th of April. Most of the show cause notices involve this issue. I'm not saying every show cause notice, but this is one issue where, because we have seen large number of audit objections as well as the ASMT 10s generated during the course of written scrutiny were related to the discrepancy between GSTR 2A versus 3B. And many people responded and they were reconciled, and there were instances where the show cause notices could be avoided, but where they could not adequately explain either in entirety or not responded, or partial to the extent not explained, not reconciled, the show cause notice were issued. So at the time of adjudication, still there is an opportunity. In this context, I would like to draw your attention to the Board Circular 183, which was issued in the month of December, 27th December 2022, circular number 183. It mainly talks about the scenarios where there is a discrepancy between GSTR 2A and 3B. And this circular speaks about the instances of such discrepancies leading to litigation only for 2 years, that is 2017-18 and 18-19. The circular also clearly says that it is not applicable for any other period, just only for these 2 years, because during this particular period, due to lack of understanding, and the people are yet to get extremely, even system was not proper, and so many reasons there were discrepancies and failures in uploading the supply details in the GSTR1, etc. So in this particular circular, the remedy provided is, if the amount involved is less than, where there is a discrepancy between GSTR 3B versus 2A, and identify the instances and identify the relevant suppliers, and if you can get a certificate, if the amount involved is less than 5 lakhs, if the supplier can give a certificate that he has filed the returns and paid the tax, that is acceptable by the department, and the discrepancy can be ignored and no liability can be confirmed. If the amount involved is more than 5 lakhs, then the statutory auditor of the supplier has to certify that these, in respect of the supplies covered by these XYZ involved. That means this exercise is to actually check whether the requirement under 16C and 16.2C and 16.2D are complied with. AA says supplier should have uploaded in GSTR1, that is in the return prescribed under section 37. 3, you should have received the goods or services or both. 3rd, the supplier should have filed returns. 5, the last one, the supplier should have paid the tax. So to check the C and D are complied with for the year 2017-18 and 18-19, this circular saves the situation. In fact, when this circular came in Tamil Nadu, we launched melas we conducted a lot of outreach programs and called people, specifically sent mails to the people to whom ASMT 10 was sent based on just only this discrepancy, and then we try to resolve that, and show cause notices could be avoided in large number of cases. But yet, for various reasons, still there are show cause notices under process where this particular issue is existing, and still at the time of adjudication or at the appellate stage, if you can take to the recourse to the remedy provided under the circular number 183 dated 27th of December 2022, it will save the situation and the liability can be avoided and the litigation can be concluded. Coming to the various decisions with regard to the discrepancy between 2A and 2B, there are good number of decisions. One important interim order which I have seen recently is Bharati Telemedia versus Union of India. It's a Delhi High Court decision, but it is only actually to bunch all cases which is to be dealt with at one go. In this particular case, court observed that the restriction imposed under 16(2)(c) are similar to the section 9(2)(g) of Delhi VAT Act. Delhi VAT Act also had a similar requirement to submit consider the ITC admissibility of VAT provided the return is filed by the supplier. So they said that particular section 9(2)(g) of Delhi VAT Act was set aside in the case of Quest Merchandising India Private Limited by Supreme Court. So taking that into clue, they said the veracity of 16(2)(c) need to be examined, and they directed the registry of Delhi High Court to bunch up all cases, and the hearing is likely, and hopefully it may come out with an observation which will provide a solution for the legislatures to further reconsider this particular requirement, which is the failure, if any, leading to litigation is in the hands of the supplier, but not at the recipient's end. The similar cases we have seen in the case of Meena Bazar Railway Station Road versus State Tax Officer, Kerala High Court. They said ITC cannot be denied solely due to the discrepancy between GSTR 2A and 3B. And yet another decision is in the case of, again, Kerala High Court, Henna Medicals versus STO, similar observation. And then we have a Madras High Court decision, but I could not get this thing. But I remember that the refund still be granted even if there is a discrepancy between 2A and 2B, and if the goods are exported, the refund still can be granted if there is a proof that the goods are exported and then the amount was paid and returns are filed by the exporter. Where the ITC admissibility was questioned, they said refund can be. This is an incidental case I thought I'll mention. Another important decision which I came across with regard to, again, 2A, 2B is Bharat Aluminium Company Limited, BALCO. In this case, they remanded the matter saying that merely based on the discrepancy, you can't cast the liability, and that need to be looked into in detail and then come to a decision. And the department has to prove that the tax was not paid or that particular supply was not accounted for by the supplier. Then only the liability can be cast upon. But in this interim decision, they said 5% pre-deposit, and then subsequently department has to re-examine like. Yeah, another decision which I came across recently is with regard to an injunction passed by Jharkhand High Court, where eastern coal fields started withholding the GST component to their suppliers on the ground that the entry is not figuring in their 2A. They said you can't stop that. And you have to take a recourse. There is no legal backing for you to stop. And the legal recourse for non-filing of return by him or non-filing of GST or wine by the supplier, that is a remedy which need to be looked into, and you can't withhold the amount of GST. I'm sure BL here is holding to all their ancillary units. That is the practice which they adopt, I'm told. So this may be useful for them. But generally, based on the normal settled positions of precedences, etc., first of all, GST itself is a specialized law, and special statutes can have special provisions, and specific provisions will prevail over general logic and general provisions. And there are n number of decisions which says that provisions of the special statute will prevail over, number one. Number two, a specific provision or requirement under law has to be given due regard unless it is absurd or impracticable. Thirdly, there are judgments which says that if a particular thing has to be done in a particular manner under law, it has to be done in the same manner, not otherwise. So, the conditions for availment of credit or restrictions in availment of credit under 17(5) are sacrosanct, they are rigid, and you can't say that this is not acceptable because catering service is used by me, why I can't use it. Earlier law, there was a decision, all those things will not be valid. So we have to see the intent of the legislature is expressed in the language employed in the statute, and the language, whatever literal meaning it conveys, has to be given due regard. We can't go beyond that unless it gives a absurd or ambiguous meaning or situation. In these provisions of the law, you will see the expression shall. In the morning, during the forenoon inaugural session, Justice Ujjal was also mentioning shall and may. He was mentioning with reference to section 69. I refer to the same with regard to even the Senvat credit relevant provisions. You will see the expression shall. So these restrictions and conditions are mandatory, and we can't go beyond that. However, in the recent judgment with regard to, as Mr. Sudhir has mentioned, with regard to Suncraft, the Kolkata High Court has given a verdict saying that for the fault of the supplier, the recipient should not be punished. Yes, provided the tax is paid and returns are filed. If the fake entity is supplying, can we take recourse to this decision? If the fake entity from Calcutta is supplying something here and it changed the hands, 1 or 2 dummy levels, and you have taken it, and material may be coming from another source and invoice coming from a different source, and actually this invoice do not pertain to this particular consignment of goods at all, you can't take recourse to this. The cardinal principle is the ITC should represent the tax which has actually reached the coffers of the government, the exchequer of the government at some stage. It might change, it might pass through several layers, but at least at the first stage, it ought to have been representing the amount paid in cash and reached the exchequer. Otherwise, all this, that is why 16.2 has been framed in such a manner to, visualizing this kind of scenarios, they made so rigid that you need to actually comply with all these 5 conditions. Thank you. I think now we can keep the session open. Maybe many people are interested to catch the bus which is destined to Yadadri, and wish you all the best. Have a blissful time. And yes, I think first
Sir, I
our
request,
friend from the front
second,
row
sir.
has raised his hand.
I request the direct access morning session chairman and the speaker also to come on to the dais. So both the direct and indirect taxes question and answers may be taken up, sir.
Yeah.
Sir,
Yes, sir. Please.
16.2 AA, do you think it's constitutionally valid? Because it is like what department cannot do directly, they cannot do indirectly.
Yeah, let us save time. We are not here to make a comment with regard to the constitutional viability or validity of any provision. We are not judges, and we only Supreme Court and High Court can make that kind of analysis and comment. So let's not talk about constitutional validity of the provisions. Is there an ambiguity in that provision?
Yeah, very much, because what department is not
and
able
then it
to
is
directly, they are asking
It's
the taxpayer to
prospective.
do it. So what department is not able to do directly, they are asking taxpayers to do it. They have shifted in the onus. So in that, there is a lot of ambiguity in that.
No, there is no ambiguity.
Yeah.
And how will he communicate the supply other than sending invoice is a communication to you, right? And that transaction need to be accounted for and should be available. It should be accessible to the department. It is possible only when it is figuring in GSTR 1. So that is the requirement. It's a requirement. See, ITC is not a scheme of the government, free. It is a beneficial scheme subject to several conditions. This is one of the conditions. So we have to accept it. If tomorrow the legislature says that ITC will be given only to MSME, not to others,
Will be question.
it's like that.
Yeah.
So it has to be accounted in GSTR 1.
Just on a lighter note,
Yeah.
see, first of all, you have been made as an agent for collection of tax by the department. Correct? You are supposed to collect from your customer and pay to the government. You are already providing a service. Now they are also saying that you ensure what you have given vendor also you pay.
So double.
So either way you are volunteered, you volunteer for extra also. That's all. On a later note.
Yeah, no problem. One question to Rajendra Prasad sir. On 43BH, so there are two things. One is it has to be looked invoice-wise or only after the invoices issued after 15 January, and whether the disallowance is permanent or temporary. Thank you.
See, okay. Number one, the disallowance is not permanent. I told you morning also, it will be disallowed first because you are not paid within the due date. Okay. The moment you paid, you are eligible to take. It is allowed as a credit. As simple as that. Suppose you paid after, see sir, you paid at 55th day. So first it is disallowed theoretically. Since it is paid within the 55th day, which is falling in the same financial year, it is allowed. It is allowed. But the other consequence which you are having is section 23 of the MSME Act is triggered. There what happens when there is a delay in payment, you need to pay interest also to the vendor. That interest is a permanent disallowance. That interest is a permanent disallowance. I hope I am clear. Yes, okay.
Sir, regarding ITC, sir, the assessee involved in a business, like he is renting an office service, like in Hyderabad, we can see that they give office space for rental for 1 hour or 2 hours like that. Yeah. Okay, in that case,
co-working space.
Co-working space, yes sir. So he has a GST license and he is a regular license, and he is working. He is renovating the office, and apart from restricted 17.5, the civil construction work is not eligible for ITC. But my question is, what about the interior works like cupboards and office chairs and partitions like with aluminum frames and tiles and some other tools? What about this ITC, whether it is eligible or not?
I got the question now. This is not only for co-working, any office space or any factory or anywhere it applies. Two things you have to look at. One is which is a civil structure, which is part and parcel of your building or immovable property. 17.5 says no credit. Orissa High Court says struck down 17.5, take the credit. Matter has been appealed to Supreme Court. Supreme Court has heard the matter, reserved the order for final consideration. So that is there, which I cannot comment. Supreme Court decision will apply. Now there are certain furnitures which is movable in nature. Like your table is there, desk is there, storage is there, which is not forming part and parcel of the building, not affixed to the building. That means if you want to remove, there should not be a substantial damage either for your furniture or for the civil structure. Even if it has been screwed, only one screw, so that the vibration will not happen. All these items you are eligible for credit. Now if you are having certain thing like false ceiling, you cannot remove false ceiling and go. It is gone part and parcel of your building. You will not be eligible for the credit. Some wallpapers are there, or painting is there. It's not there. AC, removable. And AC, as per me, is not a building. It's a plant and machinery, equipment. It's an equipment. DG, AC, those things are eligible. So what you have to do is, again, biggest problem which is coming is, although you are eligible for these items as a credit, few items as a credit, but the contract has been given to one contractor for a lump sum price, that you have to give me desk, you have to give me interior, tiles, everything. Then it becomes a composite supply, and the nature is more of an immovable property, addition to immovable property. Thereby, you will not be eligible to get the entire thing. So you want to be smart enough, you plan and give independent contract for furniture separately, non-furniture separately, so that you will be eligible for taking the credit.
Thank you, sir. One more.
Lift also should be eligible for credit, yeah.
Thank you, sir. One more small note, sir. Regarding present State Department is issuing notices regarding. So previously by wrong, the IGST credit was earlierly taken in the head of CGST and SGST. So now the department is asking to pay the CGST, SGST, the whatever the wrongly you have claimed the ITC. I am eligible for claim in IGST, sir, but by wrongly I have claimed in CGST and SGST. Now the department is asking for reverse CGST and SGST, and they are not giving any answer about IGST. So what is the, how to educate this?
Sir, you claimed erroneously, the invoice was proper, or you claimed erroneously?
Erroneously.
It's technically speaking difficult, sir. There is one section 77 which is a saver for your output tax, not for input tax. There is one section 77, what it says, instead of place of supply wrong selection, I should have paid C plus S, I have paid I. That also don't worry at all. You pay C plus S now, take a refund of I, no interest, no penalty. Okay. So E is safeguarded from an output person. But as a recipient, when I have got a credit of C plus S, but I have taken it as an I or vice versa, because it is not a credit which has gone to the state government. More important is that particular state government has not got it. So there could be a challenge. See, this is very simple. If you look at what credit I have got as a government, I can give you a set off of it. Now you are having a IGST Maharashtra invoice. The credit has gone to Maharashtra.
Yes.
You are asking Telangana government to give the credit. Why Telangana government will give the credit? So that is a problem. But judicially, if you look at, you are paid for it.
There has to be some mechanism for adjustment within the state and you should be eligible to get the credit. But technically there is a challenge. Sir, you want to add anything on that?
Do you still have time within 16.4?
16.4, no, sir.
No, the
No.
time is lapsed already.
Lapse.
Yeah, then it's a problem. Otherwise,
Thanks.
simply you can take here and reverse here. You
So
have
now
done
all the
that.
cases regarding it.
Yes, yes. Yeah, yeah.
Please, sir. Please.
Friends, this is a problem that most of the dealers are facing. Let me tell you one thing. IGST. What is IGST? What is IGST? Integrated tax. What is CST? Compare between IGST and CST. I am not saying that any section has provided anything. It is for us to challenge before the High Court.
Yes.
So, if you have any problem, come to me, we will challenge it.
This is beyond department, sir. Only judiciary can do. Kumar sir is the best for that.
See, you have to make a cost-benefit analysis also. So Kumar will charge X amount, and if it is, if your credit is at least 3 times of it, try for it.
Sir, section 16.4 got substituted as 30th November. 30th November. I am in the QRMP scheme. And for the month of October, November, December, there was no such form is exist for me to file it. In that case, do I need to forego such money? For example, it's under section 4, I can eligible to take such input. But government told me that under 16.4, you need to eligible to take such input, okay? Because there is a different view, because I am contesting the case. And the government told that you need to take it on or before 30th November of the following financial year. I am in QRMP scheme, that is quarterly return monthly payment scheme. For the October month, November month, December month, the form GST3B is not enabled to me with the GST common portal, and I can able to file such input but 22nd of the January of this year. So now my query is whether I am eligible to take an input or not. I was puzzled.
You
sir.
should take it. You should take it, and you have a strong ground. I am sure you will win, because it is not enabled.
Sir, excuse me, sir. I want to, because I argue the cases. Okay, just I want to bring one small gist of that one. Rule cannot override the act. If rule cannot override the act, form notified in the rules cannot override rules, cannot override the act, and one cannot whittle down one's rights. Section 59 is talks about tax, self-assessment, tax payable, and submit the return. It was mentioned that. And Tirumalakonda Plywood, I argue the cases in spite of the Honorable Apex Court judgment in the case of Airtel as well as the AAP case. And it was challenged it because in COVID, government issued the notifications, and subject to such conditions, if I don't fulfill the conditions, my due date is never ever extended. It means March month return is false on 20th of April 2020 and like that. This case I was argued that in relating to Erno's proceeding the officer, no DRC 01 issued it. Even order also is not saved because order is not exist on the date, number 1. Number 2, state is responsible to protect its citizens, because when my fellow citizens are dying and police given instructions not to go out, and it is covered as a red zone, yellow zone, green zone, whatever may be that. I am fear of my life, and read with the preamble, read with the Article 13.2, Article 14, Article 19.
Sir, I request, as I told you, will be already here. People who want to speak.
No, these 4 lines.
That's okay, because let's have the question answer session so that we are already overshooting the time.
Okay, you conclude in next 2 minutes or next 1 minute.
If you want to conclude, you can give your final
to
question.
only conclude, sir.
Yeah.
And when Article 21, Article 22, Article 51A, because police told me that you should not go out, and whether I need to comply my duties or I need to forego my duties, that is a query. So this is the one, I done it. Another thing is, Form GST3B is challenged because Section 38, Section 30, because with relation to returns, Section 38, 39, 40, Section 41, Section 42, Section 43, Section 7512, Section 164, government cannot make rules contrary to the provisions of the Act. And Section 7512, read with Section 62, and Section 36, Rule 36, Rule 38, and Rule 60, Rule 61, Rule 69 to Rule 77.
It's difficult for anybody to comprehend. So, why don't you summarize it? What do you want to say?
Over, sir.
In sum and substance, he says it can be challenged.
No. These rules are exist. These provisions are exist till 30th 9 2022, but it was omitted with effect from 1/10/2022 onwards. This is one I taken a case for this honorable court. That one also. And
okay, it's not your question. You are trying to present your case. Okay.
No,
thank you.
Just giving the facts.
No, it's
okay, sir. Thank you. Any other questions, sir, please?
We should give opportunity for people having some genuine.
Sir, good afternoon, sir, and thank you for Sridhar Garu for your session. My query is regarding ITC. In case of a software company where my outward is entirely supply of service, in my case, 90% of my supply is export with LUT and 10% is domestic. Now coming to my input tax, now there is no clear clarification whether 100% of my input tax I can settle for my domestic liability or 90% of my ITC should I go for refund and 10%?
No, sir. Law is very clear. There is no confusion on that. If it is an export, it is treated as zero rated supply. That means your output tax you are writing is not exempted. It is zero rate. That means you are eligible to take input tax credit. So entire credit what you take after putting into a filter of 17.5 ineligible credit, you are eligible for the entire credit. Now this entire credit you can use it for your domestic supply first. After that leftover, applying the formula, you can go for a refund. That's all.
Sir, with regard to ITC, sir, as per circular number 183, CA certificate was produced, but they are not their statutory auditors, sir. Other auditors, they have certified it. What is the fate of that claim,
no,
sir?
If statutory auditor is not there and if they are not actually having the, they are not coming under statutory audit, if it is given by a normal chartered accountant, it should be accepted. There are two conditions. One, there should be that their DIN number. Number two, it is a settled position that no chartered account certificate by itself can be admitted. It should indicate what are the documents based on which it is issued, and such documents should also be made available for cross verification. A chartered accountant certificate without supporting documents is not null, it's not valid.
Okay, sir.
So and
just
the
because
circular
of
also says the DIN number of the chartered accountant should be there.
Yeah, UDIN number and all that was generated, sir. But just because of some internal issues between the client and the chartered accountant, he has changed the auditor, and
that
some other auditor was
that
given.
That reason can be offered, and the certificate can be with supporting documents. If it is given, it should be generally accepted by the department.
Okay. I feel as far as 183 circular, it's a chartered accountant. Statutory auditor is not mentioned. So any chartered accountant who is qualified to give a thing should be sufficient. Sir is anyway checking. He will clarify that.
Okay.
Very important when we look at this 183 circular and another 193 circular for the next two financial year. Don't think that the problem is solved that if you just give one declaration, your problem is solved, because based on declaration, your supplier will be subjected to verification. That is what is going to be done in phase 2 by the department. Because I've seen few people coming and proposing, sir, who knows, sir, below 5 lakhs is lettered, I'll generate and I'll give. Boss, you are doing something fraud. Your small problem, you are making it a big problem. You take it from the vendor, or anyway, I told you one case, Lana, that 2022 onwards only it's there. You take that route. Don't take the second route. Okay. So that is...
Yeah, I correct myself. Wonderful observation.
Yeah.
It is not statutory auditor. It is the chartered accountant or the cost accountant. So it do not say
you have
statutory
specifically
auditor.
mentioned that, sir. We have to obtain from the statutory auditor. That's why I'm asking. In some case, we have produced...
Circular.
Yeah, okay.
I did not read properly.
Okay, sir.
I'm reading it now.
Right.